Yeah, wait. Yes. Preeti, you can go live. Yeah, we are live on YouTube now. Thank you. Over to you, Preeti.
Good evening to one and all present here today. I'm Preeti Mahendra, student of 3-year LLB, Vivekananda College of Law, Bangalore. On behalf of Vivekananda College of Law, I cordially invite you to this special lecture on Law of Torts and Overview. Before we get on with the lecture, I request you all to please mute your mics, raise your hand and share your queries in the chat box, as we shall answer or take up any questions at the end of this lecture. Thank you. These lectures are carried out from the 13th to the 17th of March, and I urge you all to attend it as we get first-hand knowledge from our guest speaker, Professor K.B. Vasudeva. Professor K.B. Vasudeva, sir, Director of Legal Studies and former Principal of Vidyavartaka Law College, Mysuru. I welcome you, sir, and thank you for joining us today.
Thank you, madam. Thank you.
Professor K.B. Vasudeva joined Vidyavartaka Law College as a lecturer in 1986, and in 2003, he was promoted as Reader in Law, followed by being promoted as a principal and professor in 2007. Sir has served as visiting faculty in the postgraduate studies in law, Manasa Gangotri University of Mysore. Now he is teaching in PG Department of Commerce, which is MCom, Vidyavartaka First Grade College, Mysore. He is also a resource person to Karnataka Police Academy to teach Human Rights and Evidence Act, along with being a resource person to NSS Training Center, University of Mysore. He has served as coordinator, Mysore Study Center, Indira Gandhi National Open University for nearly 10 years. Sir has also served as Secretary, Youth Hostel Association of India, Unit 1, Mysore. He has presented various law papers in both state and national level seminars. Professor K.B. Vasudeva, sir, has also been a resource person to Administrative Training Institute, Mysore. Over to you, sir.
Thank you. Can I share? And Zoom ಮಾಡಬೇಕಾಯ್ತು. Okay. Thank you, madam. Thank you. Good evening to one and all. I should say my academic career was recognized by Vivekananda College, especially Bhuvaneshwari madam. Every year she is not leaving me actually, at least to share my knowledge with, and never actually I differentiated whether Vivekananda and Vidyavardhaka both are integral part, and all of them were teaching in Vivekananda are all friends, and especially Kempegoda sir actually was very close friend of mine. So every time he pressurizes me to take this particular area. This is very interesting aspect, especially law of torts. Only worry was that Indian judiciary was not taking law of torts in their practice, like European countries and America, UK, because developed in UK only, and that's why we are worried actually. Say whenever we ask for that, they say everything covered under Indian Penal Code, and that's why especially awarding damages, if the Indian judiciary considers this particular branch of law in practice, probably the benefits goes to victims or affected parties to get some qualified compensation. I'm saying that. I don't say handsome compensation. Only the question is whether to compare with European countries and Indian scenario. Every time when we speak, whenever we refer to decisions of UK, we only question that the value of life of an individual measured in India and elsewhere, the value actually compared to Western countries, actually not.
Vasudeva sir, Vasudeva sir, sorry for the disturbance. We
Really?
cannot see your video.
What is it?
Yeah, you are not there on the video. Just we are listening to your audio, sir. Again, the video is off now. Iವಾಗ ಆನ್ ಆಯ್ತು.
ಈಗ ಆಯ್ತು.
ನೋಡುತ್ತೀನಿ ಸರ್, ಒಂದ್ ನಿಮಿಷ ಸರ್.
ನೋಡಿ
ಇಲ್ಲ ಸರ್,
ಅದು
ನಿಮ್ ಸ್ಕ್ರೀನ್ ಶೇರ್ ಆಗಿಲ್ಲ.
ಓ
ಹಾ, ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡಿ ಸರ್, ಏನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅಂತ.
ವಿಡಿಯೋ ಬರ್ತಾ ಇದೆ, ಸ್ಕ್ರೀನ್ ಒಂದ್ ಶೇರ್ ಆಗಿಲ್ಲ.
ವಿಡಿಯೋ ಬರ್ತಾ ಇದೆನಾ? ಓಕೆ,
ನನಗೆ ಆಫ್ ಆಗಿತ್ತು, ಅದಕ್ಕೆ ನಾನು ಇದ್ ಮಾಡಿದೆ ಬೇರೆ.
Okay, sir. You can continue, sir. Students, you can see sir and the screen?
Yes.
Yeah, ma'am. You can see.
Okay. Then continue, sir. Continue, sir.
I'll share idu.
And I even welcome Kempegoda sir, our beloved principal, has also joined the session. Yes, yeah, a warm welcome reserved to you, sir.
Good evening, Dr.
Sir. Good evening, sir.
Good evening,
sir. Thanks for accepting our invitation.
Okay.
Thank you very much. Please continue, sir. Please continue.
Okay. ಏನಿಲ್ಲ, ಜಸ್ಟ್ ಝೂಮ್ ಮಾಡ್ಬೇಕಿತ್ತು ಅಷ್ಟೇ. ಈಗ ಬಹಳ ದಿನ ಆಗೋಯ್ತಲ್ವಾ ಸರ್ ಇವಾಗ?
ಹೌದು.
ಹೊರತೋಗಿದೆ.
ಎಲ್ಲಿ ಝೂಮ್ ಮಾಡ್ಬೇಕು.
Old timers, sir. We are all old timers. Okay, sir. Please continue.
ನೋಡಿ, ಇದು ಝೂಮ್ ಮಾಡ್ಬೇಕು, ಆ ಕಡೆಯಿಂದ ಆಗತ್ತಾ ಅದು?
ಅದನ್ನೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ. someone is sharing our screen also. ಏನು ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
Driving mode. Someone is driving.
Someone is
ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಸರ್, ನೀವು ಸ್ಕ್ರೀನ್ ಶೇರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್, ನೋಡೋಣ.
ಅಲ್ಲ, ಸ್ಕ್ರೀನ್ ಶೇರ್ ಮಾಡಿದ್ದೀನಿ.
ಓಕೆ,
again same problem.
ನಿಮ್ದೇ ಸ್ಕ್ರೀನ್ ನಮ್ ಜೊತೆಗೆ ಶೇರ್ ಆಗಿದೆ. ಓಕೆ, ಝೂಮ್ ಅಂತ ಬರ್ತಾ ಇದೆನಾ ಸರ್? ಇದು ನಿಮ್ದೇ ಸ್ಕ್ರೀನಾ ಸರ್? ಸರ್ ಪಿಪಿಟಿ
ಬರ್ತಿದೆಯಲ್ಲ, ನಂದೇ ಸ್ಕ್ರೀನ್.
ಓಕೆ, ಪಿಪಿಟಿ ಎಲ್ಲಿ ಇರುತ್ತೆ ಸರ್ ನಿಮ್ದು? ಅಲ್ಲಿ ನೋಡ್ಕೋಬಹುದು ತಾವು.
ಪಿಪಿಟಿ ಹೋಗ್ತೀನಿ. ಇದು
ಸರ್
ಶಾಪ್ ಶೇರ್. ಈಗ
ಸ್ಕ್ರೀನ್ ಹೊರಟೋಯ್ತು ಸರ್. ಈಗ ನೀವು
ಸ್ಕ್ರೀನ್ ನನಗ್ ಕಾಣ್ತಾ ಇದೆ ನನ್ ಕಡೆಯಿಂದ.
ಓಕೆ, ಇವಾಗ ಮತ್ತೆ ಗ್ರಿಡ್ ಅಲ್ಲಿ ಬಂದ್ರಿ. ಇವಾಗ ಶೇರ್ ಮಾಡಿ ಸರ್, ನೋಡೋಣ ಇನ್ನೊಂದ್ಸಲ.
ಈಗೆಲ್ಲ ಓಪನ್ ಇದೆ, ಇನ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ?
ಮ್ಯಾಮ್ ಒಂದ್ ನಿಮಿಷ ಸರ್, ಶೇರ್ ಸ್ಕ್ರೀನ್ ಒತ್ತಿ ಸರ್. ಇಲ್ಲಿ ಝೂಮ್ ಅಲ್ಲಿ ಶೇರ್ ಸ್ಕ್ರೀನ್ ಒತ್ಬಿಟ್ಟು ಇವಾಗ ಶೇರ್ ಆಗಿದೆ ಸರ್. ಇವಾಗ ನಿಮ್ ಪಿಪಿಟಿ ಓಪನ್ ಮಾಡಿ ಸರ್.
ಪಿಪಿಟಿ ಆಮೇಲೆ ಓಪನ್ ಮಾಡ್ತೀನಿ. ಸ್ಕ್ರೀನ್ ಓಪನ್ ಆಗಿದ್ಯಾ?
ಓಪನ್ ಆಗಿದೆ ಸರ್.
ನನಗೆ ಸ್ಕ್ರೀನು ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ, ರೈಟ್ ಸೈಡ್ ಅಷ್ಟೇ.
ಸಾಕು ಸರ್, ನಿಮ್ ಪಿಪಿಟಿ ಓಪನ್ ಮಾಡಿ.
ಓಕೆ, ಪಿಪಿಟಿ ಮಾಡ್ತೀನಿ. ಓಕೆ, ಫೈನ್. ಓಕೆ, as I said, in Indian scenario, actually the problem is that whether exactly the judiciary evaluating the life of Indian
students. One ನಿಮಿಷ sir. Students, can you see sir screen?
Only Zoom.
Only Zoom we can see sir. We are not
open ಮಾಡಿಲ್ಲ ಮ್ಯಾಮ್.
ಸರ್ ನೀವು ಓಪನ್ ಮಾಡಿಲ್ಲ ಅನ್ಕೊಳ್ತೀನಿ. ಪಿಪಿಟಿ ಓಪನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಎಲ್ಲಿದೆ?
ಓಪನ್ ಪಿಪಿಟಿ ಓಪನ್ ಇದಾಗುತ್ತಾ?
ಪಿಪಿಟಿ ಅಂತ
participants. Okay, so
ಸಿಕ್ತಾ ಸರ್?
ಅಲ್ಲಿ ಕೆಳಗಡೆ PPT symbol ಇದೆಯಲ್ಲ ಸರ್ ಅದನ್ನ ಕ್ಲಿಕ್ ಮಾಡಿ ಸರ್.
Yeah, sir. Now we can see your PPT, sir.
PPT
Yeah.
ನೋಡು, PPT
ಇವಾಗ we can see now, sir. Yeah.
It's
You
fine,
can go ahead. Sorry for the interruption, sir. Now you.
Okay, right. Okay. Okay, as I said, I don't know about the experience of many professors. Whenever I talk about the law of Totrs, I'm saying that my worry actually is why can't the Indian judiciary should consider the especially law of Totrs in claiming for civil wrongs. The question, as I said earlier, the evaluating the life of Indian citizens by Indian courts, rather compared to the Western countries, not far better. I'm saying that. Why? Because the lesser the compensation system actually was seen since many decades. Many people ask for that. Why this is? Because courts are inclined towards only the remedies available under Indian Penal Code. It's something falls on the borderline. Though these are all civil wrongs, the fighting spirit of the individuals is also not encourage you actually, and that's why probably the law of Totrs as a branch of law developed, but not reflected in the practice actually. Okay, and the Indian Penal Code actually was considered to be better than this, because for example, negligence is crime as well as a tort, defamation the crime as well as a tort, assault, like that. There are many civil wrongs considered as crime, so better always chooses to take up the criminal side, of course, not civil side, and that is why I don't know whether easy to get because what they Indian Penal Code actually is, you will get only the punishment. Say, I don't know, even the many courts actually not encourage you, because compensation can be awarded even under CRPC by way of fine that can be given to victims. Not much cases actually was decided on in that manner. Probably, I don't know, in the rape cases, especially in only few cases actually such practices was adopted by the courts. This is one area where I am worried. I'm saying that. Okay, fine. Indian law of Totrs, as we are aware, deals with civil wrongs, and especially, of course, violation of personal rights, private rights. But there are areas was included, like Consumer Protection Act, Motor Vehicles Act. These are all areas where try to touch upon the individual, and that's why it is clubbed as one branch of law, I'm saying, and they try to bring awareness to the students. That is the one agenda where the academics tells that the awareness should be given to the people by introducing in their syllabus. That's why we are studying today RTI, Consumer Protection Act, Motor Vehicles Act. Like many subjects actually was taught because to bring, especially environmental law, as an awareness program, of course, awareness program, and it became a syllabus for us, especially law students, to study this particular area. Now, coming to this law of Totrs, we start with the word called tartum. Tartum is a Latin term It is what you mean by twisted. The object of the law is to regulate the conduct of the people, and hence we have to set right the conduct of an individual. What we see is the conflict of interest. One, at the same time, whatever the rights recognized as individual rights, so one has to protect them. See, that's why it is simply considered as a tortious liability, and one can approach the court to get a civil remedy, of course. ಅದನ್ನು civil wrongs ಅಂತ ನಾವು ಹೇಳ್ತೀವಿ. So that is one area, of course. Now my point is that the Tots developed in England because of their civilization, their very sensitiveness towards their rights, the awareness. I'm saying that very sensitive English individual, where he tried to justify whenever the wrong committed against his rights. So that is one area. But in Indian scenario, it's very difficult because of poverty, literacy, and not bent of mind. And that means to approach the court of law. I'm saying never. That always dislikes to go to court of law, even though we are aware of many rights. So that's only the difference between those countries and us. And now at present, actually, because of the industrialization, urbanization, and because of the civilization, and now we are approaching the courts actually and getting the remedy, and courts also somewhat encourage you and encouraging us to at least to get the compensation considerably, of course, not, I don't say handsome compensation, of course. When the entire law of torts, when you see the Indian case laws, the compensation awarded was not up to the exact value of the life. I'm saying that this is only the question how to measure the value of life and the quantum of compensation. Only one word what we use as far as possible, reasonable compensation. When you study the different kinds of damages, we have heard nominal damage, contemptuous damage, compensatory damage, and aggravated damages, exemplary damages, prospective damages. So when all these different kinds of set of circumstances, based on that, the courts used to award the compensation. So most of the cases actually awarded very less, dragging from many stages, lower court to even up to Supreme Court, or even high courts. Say the compensation system was not encouraging. That's what I said. Now coming to these are the objectives when you are studying a subject. This course actually designed that recognizing the individual rights and also the defenses available to justify between the plaintiff and the defendant. Some of the chapters deals with common protection of common rights, and there are some specific torts also. Now individual property and the individual rights was recognized. Okay, and as I said, an attempt shall be accorded to the individuals against mass torts and industrial torts. When I say industrial torts, environmental law, okay, and mass torts, maybe defamation or maybe trespasses. There are many nuisance, especially nuisance, public nuisance. These are all areas covered under this particular law of torts. I'm saying that keeping in the expensive character of judicial proceedings, the students should reflect the alternative forms and also the remedies provided under the Consumer Protection Act. Say the alternates what we had is the courts where quickly they can dispose the problems. That's why consumer courts came into being. It's not 1986, now 2019. 1986 was the initial enactment made, and somehow we experimented till 2019. 2019, again, complete change was made, and there is a new law, Consumer Protection Act 2019, of course. Until today, motor vehicles accidents were never considered as a crime, and tortious, I don't say civil wrong, of course. Even the death also considered as a civil wrong, not very serious, of course. But when come to they have included in the syllabus. But my point is that the quantum of compensation actually is the question. Of course, I will stop to this particular object. We are all aware of syllabus, and hence I will take up the first unit only one chapter, second unit 2 chapters, unit 3, 4, 5, 6 chapters. Unit 4, several small matters also included. Apart from trespass to the person, 3 areas covered: assault, battery, and false imprisonment, and defamation, malicious prosecution. These are the few major areas, but remaining are torts affecting domestic and other marital rights, parental rights, right of services, contractual rights, intimidation, conspiracy. See, intimidation, conspiracy, all those things study in Indian Penal Code. Torts against property. These are all included in the 4th unit. Consumer Protection Act, as I said, 2019, of course. And we always recommend the students to study law and Dheeraj law prescribed. Okay, but now you have to refer, Bear Act, especially 2019 law. But my passion, my understanding of law of torts is from Winfield and Zolovis. And even I studied Clerk and Lindsell. I am not mentioned here actually. One of the prominent book on law of torts, Clerk and Lindsell. That is both useful to practitioners as well as academicians. Winfield and Zolovis is an authority, as we understood. And the narration given in that book was so wonderful and wonderful. If many people who have not read, please go through Winfield and Zolovis. Remaining are Indian authors. You can go through, no issues. But as a student of law, we recommend every student to study the recognized, well-known books. Then only your analytical capacity increases. Your understanding towards the law and the application to the issues or to the society, of course, this can be well understood. Otherwise, it's only from the examination point of view we study, of course. Okay. I said tortum, delict, tort. These are all words already you are known. Tortum means twisted. Delict, again, Roman word, wrong, and tort means French term. Say, these are all terminologies where we got regarding the civil wrong. I'm saying that the object of all laws actually to regulate the conduct of the people. Wherever they are go away from the law, outlaw. When you say outlaw, of course, these people were normally, I don't know, of course, how to identify the development of law of torts, especially. Even before 12th century or from 12th century, we have come across the manner of awarding the compensation, or manner of recognizing the legal rights, only by looking to the damages. So that's why I am mentioning here the first writ recognized, a writ of trespass. Writ, now what we see today is different. Writ, there is no compartmentalization of wrongs. Like today we have negligence, defamation, strict liability or assault and battery, false imprisonment, malicious prosecution. Likewise, we come across various heads, but writ of trespass where remedies were available for all types of wrongs. If it is a defamation, writ of trespass. If it is a negligence, writ of trespass. Anything, assault and battery, writ of trespass. Say damage to property, writ of trespass. Say mobile property, trespass to mobile property, writ of trespass. For all wrongs, actually, the courts used to give remedy by way of writ of trespass. And then after some time, the fraud is recognized as independent wrong. That's why the courts entertained writ of deceit as a separate writ, recognizing the fraud as a separate wrong. So whoever commits a fraud, they are filing writ of deceit. Rest of writ of trespass. And again afterwards, they recognize the writ of replevin. Replevin refers to the encroachment of any immobile property, the restitution of the property. That's why the courts, especially the wrongs towards the property, was recognized under the writ of replevin, and remedies available. And that considered as wrongs against the property was recognized as replevin. Another writ of trover. Trover means conversion. This is conversion. It refers to mobile goods, destroying the identity, damaging, etc., and saying that you are converting it into different form. So even selling the property and converting it into cash, it is simply called as conversion. So for these wrongs, writ of trover was recognized. So these four are okay, fine. In different stages, actually, after 12th century, they are recognized. But very important, actually, the writ of assumption. This writ actually is basis for the breach of contracts. Especially whoever teaches the law of contract has to mention this particular writ of assumption. Assumption means one who undertook obligation. The entire contract is accepting the obligation, of course, contractual obligations. One who undertook the obligation. This is what I call assumption. Under contractual, wherever there is a breach of contracts, breach of any transaction, remedies were available under writ of assumption, of course. These writs means when the wrongs committed and the person suffered damage, the courts looks towards the damage caused to him and then recognized the legal rights, whether he is fit to receive the compensation or not. So that exactly the point, of course. So that's why what we call ibi jus ubi remedium. Ibi jus where ubi remedium, of course. So where there is a remedy, there is a right actually. Adu ibi remedium ubi jus. Adon ಸ್ವಲ್ಪ ತಪ್ಪಾಗಿದೆ. Ibi remedium ubi jus. Where there is a remedy, there is a right actually. Okay. But after that, Fatal Accidents Act, injuries to unborn person, there are several enactments came into being. And then the very first task of what you call duty of the court is to recognize the legal right of the person. When I say rights, you are all aware. You study from the Constitution of India. You say that fundamental rights, and also in the Constitution, you will say constitutional rights, and then you say statutory rights. In some other times, you say the legal rights. You say human rights. Different statutes, legislations, the customs, the precedents used to recognize the legal rights. That's exactly the task of the court, is to recognize the right of the individual, and then every right should have a remedial course. So that's why the propounded this one, ubi jus, ibi remedium, where there is a right, there is a remedial course. So these are the few fundamentals as far as the development is concerned. You are aware of why law of torts actually not developed in India. The first one actually is that lack of awareness, illiteracy, and spirit of toleration. Spirit of toleration. Spirit of toleration, we are aware that Devridane Nodkalana, Devridane Nodkatane. But I don't want to justify my right, but I will leave it to the God to punish him, of course. Devru avನಿಗೆ ಕೆಟ್ಟದ್ದು ಮಾಡ್ತಾನೆ, ಅವನಿಗೆ ಆಗಾಗುತ್ತೆ, ಹೀಗಾಗುತ್ತೆ, ಏನೋ ಶಾಪ ಹಾಕ್ಬಿಟ್ಬಿಡ್ತೀವಿ ನಾವು ಅಷ್ಟೇ, that's all. So that is that most of the problems are not taken to the courts because we have that particular. ಕೆಲವು ಸರಿ ನಾವು ಅನ್ಕೊಳ್ಳೋದು, ಅಯ್ಯೋ ನಾನು ನೆನೆ ಬರಸ ಇರಲಿಲ್ಲ. If suppose there was a quarrel in a crowded theater, you will always think that my fate, I should not have gone there. Something happened in a bus, I should not have gone there. Like that. ನಾನು ಹೋಗ್ಬಾರ್ದಿತ್ತು ಅಲ್ಲಿಗೆ, ನಾನು ಓದೋದೇ ತಪ್ಪೇನೋ ಇವತ್ತು, ಮನೇಲಿ ಇದ್ರೆ ಏನೂ ಆಗ್ತಿರ್ಲಿಲ್ಲ. This is exactly the mentality of an individuals. Say that even though they are aware of rights, there is no bent of mind to justify their rights. I'm saying that. ಅದು ಒಂದು ಕಡೆ ಇರುತ್ತೆ. ಇಲ್ಲಿ literacy and our poverty, all those things actually, the cost of litigation is always makes us to go back. I'm saying that. And then never come forward and never step forward to go to court. I'm saying that. I say that that's my last wish. Police station ಹೋಗೋದಾಗಲಿ ಅಥವಾ court ಹೋಗೋದಾಗಲಿ, never, I'm saying that, never. So that's why in the history what it says that, say we used to refer everything to the God and goddesses and say blaming ourselves, and also what do you call the spirit of toleration. ನಾವು ಹೇಳ್ತೀವಲ್ಲ ಅಹಿಂಸಾ ವಾದ, non-aligned movement. There are many. The history of India speaks many things. Hangagi the people never venture to go to courts actually. So that is one area, one point actually. Spirit of toleration is that. Second one, whenever suppose the people who approach the court of law saying that the courts showed its negative tendency in recognizing the legal rights. For that, so many examples we give actually. Not recognizing the legal rights. Athwa they always looks towards the precedents. Inde yaru recognize madidara ilva adannu nodta hogtare. So if the courts, when there is no precedents, never they courage to recognize any rights. Adu atharno agide. And then again the quantum of compensation given by the courts are very less. And then undue delay, of course. Even today, we are aware adjournment lies ante ಹೆಸರು ತಗೊಂಡವರು ಇದ್ದಾರೆ. Because of CPC, because of there is undue delay in deciding the cases. Adu ಒಂದು. Poverty, as already said. So undue delay in deciding the cases is delayed justice anta ನಾವು already understood, of course. Another very important point is king can do no wrong. King can do no wrong. Now English 1947 Crown Proceeding Act was passed, but still the way in which our government works actually, they always claim the sovereign right. No vicarious liability. Now ಈಗೆಲ್ಲ ಡೆವಲಪ್ ಆಗಿದೆ, fine, but I'm talking about the post-independent scenario bandaga, even up to 2000. The sovereign immunity was claimed in many cases actually. But Crown in 1947 accepted the vicarious liability of their servants wrong. But now Allah, now we started dividing the two aspects, sovereign act and non-sovereign act. Sovereign act, immunity extended. Non-sovereign acts, the liability was fixed actually. So ಅದನ್ನೆಲ್ಲ ನಾವು ಹೇಳ್ತಾ ಹೋಗ್ತಿರ್ತೀವಿ. Non-sovereign act ಯಾವುದು ಅಂತ we have to decide, of course. Normally we give one example. Suppose a military truck carrying food, arms and ammunitions. ಬೇಡ ಸಾಕು ಒಂದೇ ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಡ್ತೀನಿ. Foods to war field. This can be considered as a sovereign act. Carrying arms and ammunitions, sovereign act. Carrying soldiers to war field, sovereign act. Suppose you are carrying a football players, they are also soldiers, football players to football ground. If something accident took place and somebody died, it is considered as a non-sovereign act. While carrying food and arms and ammunitions meant to war field, if anybody died in any accident, say sovereign immunity was extended. This is exactly how we understood the liability of the state, or the vicarious liability of the states. So direct responsibility is required, of course. So that is one aspect. That's why there are many issues why the law of torts not able to achieve or not able to develop in Indian scenario, of course. ಹಾಗಾಗಿ ಅದು ಆಗ್ಲಿಲ್ಲ, of course, but ಕೆಲವು ಸರಿ ಅಕಾಡೆಮಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಓದ್ತಿದೀವಿ ಅನಿಸ್ಬಿಡುತ್ತೆ ಸರ್ ಇದನ್ನೆಲ್ಲ ಓದುವಾಗ. Okay, fine, but very interesting area. Now I'll take up definition. ಹಾಗೆ ಕೆಲವು ಪಾಯಿಂಟ್ಸ್ ಗಳು ಮಾತ್ರ ಹೇಳ್ತಾ ಹೋಗ್ತೀನಿ, ಯಾಕಂದ್ರೆ ಆಲ್ ಸ್ಟಡಿಡ್ ಅಂಡ್ ದಟ್ ಇಟ್ ಇಸ್ ಒಂಥರ ರಿಫ್ರೆಶಿಂಗ್ ಯುವರ್ ಮೆಮೊರಿ. While writing in the examination, I always suggest that you have to write Winfield's definitions. ಗೊತ್ತಿಲ್ಲ ಬುಕ್ಗಳಲ್ಲಿ ಏನೇನು ಸಿಗುತ್ತೆ ನಿಮಗೆ ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, but Winfield definition is an opt definition and you have to write Winfield definition. He uses the word, tortious liability, ಅಪಕೃತ್ಯದ ಹೊಣೆಗಾರಿಕೆ. Now, how are you going to define anything, of course? Definitions bandaga, there are two types of definitions: inclusive definition and exclusive definition. Idhu ನೀವು ನೋಡಬೇಕು. Exclusive definition except etc ಅಂತ ಹೇಳ್ತಾರೆ. Inclusive definition, they try to mention certain things, actually try to bring within their framework and define. Some definitions, they specify something and they will say except. Let us see that. Tortious liability arises from the breach of duty primarily fixed by the law. So, primarily fixed by the law, actually. It is not moral, it is not religious or any other type of father. Say it should be a legal duty, I'm saying that. Legal duty. Any contract entered between two individuals is considered as legal duty. Any contractual obligation, contractual rights, contractual obligations, that is considered as a legal right, where two individuals can enter into and create a legal duty and legal rights. So that is recognized by Indian Contract Act. Similarly here, torts, when I say any duty fixed upon any individual, it should be by law, legal duty. So tortious liability arises from the breach of duty primarily fixed by the law. So when there is a breach of legal duty, of course, legal right, legal duty. So Winfield defining the term tort from defendant's point of view. So you have a legal duty. If you commit a breach, you are responsible. That's all. So this duty is towards persons generally, that means towards society. And its breach is redressable by an action for unliquidated damages. So legal duty, number one, duty fixed by the law, primarily fixed by the law. That's the beauty of Winfield always. Duty fixed by the law ಅಂತ ಹೇಳ್ಬೋದಿತ್ತು, primarily fixed by the law, ಪ್ರಾಥಮಿಕವಾಗಿ ಅಂತ ಹೇಳ್ತಾನೆ, primarily fixed by the law, but duty towards the society. But plaintiff is always one of the member of society, so to whom the injury caused, so he comes forward and takes action against the defendant. So that's why duty is towards persons generally. ನಾವು ಹೇಳ್ತೀವಲ್ಲ, in personam or in rem ಅದನ್ನ ಹೇಳ್ತಾ ಹೋಗ್ತಿರ್ತೀವಿ, but it becomes in personam when the individual identified as a plaintiff of course. General ಆಗಿ ಹೇಳಿದರೆ in rem ಅಂತ ಹೇಳ್ತಿರ್ತೀವಿ ನಾವು. So its breach is redressable by an action for unliquidated damages. Redressable compensation can be given, of course. Remedy can be given, of course, by unliquidated damages. Of course, your course teachers already explained two kinds of damages: liquidated damages, unliquidated damages. The only difference between these two, liquidated damages, you can identify under law of contract or any other laws where the parties themselves can, fix the value of their transaction. Transaction ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂತ ಹೇಳ್ಬೋದಿತ್ತು, ಕಾಂಟ್ರಾಕ್ಟ್ ಅಲ್ಲೂ ಅಷ್ಟೇ ಗೊತ್ತಾಯ್ತಲ್ಲ. They determine, suppose the value of the contract is 50,000 rupees, the court will award, in case of breach, the court will award 50,000 rupees. Say liquidated damages, the parties themselves. Any transaction has a value of the contract, value of the transaction, they can claim to that extent. The courts cannot go beyond the damage or value of the contract and award it. Sometimes if the conditions are different, say to pay double the amount. But one thing understand, while studying contract, the courts never entertains the unreasonable conditions. It only recognizes the reasonable conditions, and that's why liquidated damages awarded. So you can enter into contract and agreeing for unreasonable unreasonable conditions, but the courts, though you have given voluntary consent, the court will not entertain. So they struck down, the conditions are unreasonable. Now coming to unliquidated damages, the parties cannot determine the quantum of compensation. They claim, definitely I will agree that, suppose there is a injury to leg, they may claim 50,000 rupees, the injury to hand, they may claim many say big amount. Suppose if there is a death, they may claim, but ultimate discretion lies with the court to measure the damages in accordance with the damage. That's why we come across nominal damage, contemptuous damage, compensatory damage, aggravated damage, and exemplary damage, and prospective damages. Varied different kinds of damages to different sets of circumstances the court awards. That's why this is simply called unliquidated damage. For example, a sports person met with an accident, lost his legs. Say he gets the measure of damage is very high and the compensation may be very high. Suppose an ordinary person, say who is not a sports person, ordinary man, say if he suffered from leg injury, and definitely say the compensation may be very, very less. So that these are the things. Head injury, or any bodily injuries, of course, depends upon the person. So that's why ultimate discretion lies with the court to determine the quantum of compensation. So when I say unliquidated damages, understand the kinds of damages, because different kinds came into being because of different set of circumstances. Say the court awards in accordance with the set of circumstances, looking to the nature of injuries, of course. So the ultimate discretion lies with the lies with the court. That's why it is called unliquidated damages. I'll give an example. Normally, a girl actually was injured while traveling. Suppose not married, one aspect, and she was prevented from participating sports, prospect of marriage, and there are many things say normally taken into consideration. So that's why each case is different, and that's why the court has discretion, not the police. The claim, that is quite natural. The advocates measure the damages and demand for the compensation, but say ultimate discretion lies with them. In one case, actually, an unmarried girl met with an accident. There is a multiple injuries, and including to her abdomen. Normally, even the child in the womb also can get remedy under law of torts. Injuries to unborn children, in ventre somnia, child in the womb. Say when recognized as a person, and any injury to the mother's womb, and she can claim compensation for injuries to the child when it was born disabled. Okay, fine. If she was a pregnant woman, if the child injured, let us say, and child born disabled, and he got the compensation. No worry, of course, it's recognized. It's recognized in almost in all cases. But here is a point: unmarried girl injured in an accident, and there is a injury to her abdomen. After some, she recovered the compensation for her physical injuries. Accidental but the next point, after some years, she married, and when she conceived and gave a birth to a child, but the child born disabled. The medical report says that because of previous accident, previous injury to her abdomen, this is the reason I'm saying. And even in future, any number of child she want, say all the childs born disabled because of there was an injury to her abdomen, of course. So when the child born, it was disabled, and now the question now, when the child in the womb can be claimed, but when she was unmarried, already got the compensation. Now injury continuing, what is the prospective damages? Prospective damages was not anticipated at that time. Now a doctor says that it is because of earlier accident. Now the question actually was whether she is entitled to recovery for the for the birth of a disabled child because of previous injury. Can you go back? Can you again file a case against that person who was a wrongful person, is a negligent driver? There's exactly the law of torts were extended. That's why when we talk, I think teachers will tell you the law is applicable between the birth to tomb ಅಂತ ಹೇಳ್ತೀವಿ, to death ಅಲ್ವಾ, ಹುಟ್ಟಿನಿಂದ ಸಾವವರೆಗೆ law is apply ಮಾಡ್ತೀವಿ. But they were also given plenty of examples that even before birth, when the child in the womb, the law applicable. After death, law applicable, because the reputation after death, the reputation of that individual becomes the family reputation. Whoever injures the family reputation, and legal heirs can take action for defamation. Best example, actually, I don't know. Please ask your teachers. Avaste, film Avaste, long back. Actually, it was released. It was a case. It was a film made on Shantaveri Gopalagowda, is a socialist and reputed personality in Karnataka, who is a follower of Ram Manohar Lohia. The film was shown that he was a drunkard, a womanizer, and evil of all nature. That's how the film showed only 1 week. Immediately, the legal heirs brought action and filed a writ and brought permanent injunction, because even after his death, this is not the way of causing injury to the reputation, because Shantaveri Gopala Gowda's reputation becomes a family reputation. It is a responsibility on the part of the legal heirs to say protect the reputation of that family or father. But at the same time, we are given example of Bhagyalakshmi Chitramandir case, where the court gave a different type of decisions. So these are all few examples speaks about unliquidated damages. Normally, medical medical expenses and prospective damages. Say everything will be claimed under unliquidated damages. Okay. Please refer to Winfield only, of course. Salmond, he says, is a civil wrong, but that word not used by Winfield, civil wrong, for which the remedy is a common law action. And the common law countries, common law, customary law, there were no judicial, legislations to deal with law of torts, and that's why everything is a product of judicial decisions. Law of torts is a product of judicial decisions, actually. So whenever people go to court of law and say that the courts gave a decision, the decisions becomes the law of that country. What you call that as law of torts. Common law action for unliquidated damages, and which is not exclusively the breach of contract or the breach of trust or other merely equitable obligations. I'm going to say questions will get there. All civil wrongs are, all torts are civil wrongs, but all civil wrongs are not torts. A breach of contract and breach of trust, other any equitable obligations were not law of torts, but it's a civil wrong. Civil wrong and the Salmond is said. The phrase it is an infringement of right in the realm of a private individual. Duty towards the society. The entire society has a right not to violate their personal rights, private rights. If a private individual, whoever injured actually becomes a private individual, one of the member of the society, and he entitled to get the compensation by filing a suit. That's what I said. It is an infringement of a right in realm of a private individual, giving a right of compensation at the suit of injured party, of course. Fraser. Limitation Act. Tort means a civil wrong which is not exclusively breach of contract. Salmond and Limitation Act, Section 2M of Limitation Act makes no difference. So it's only a civil wrong where not so serious. You can go to civil courts and you can claim the compensation, of course. But breach of contract is different. Now, after studying the definition, these three were to identify tort is a civil wrong, breach of duty, and unliquidated damages. These three are essentials of the law of torts. I'm saying that. Explain brief distinction between tort and contract, actually. Tort is civil wrong. Contract is also civil wrong. This makes no difference. But both are legal duty, actually. Both are. And individuals can, by entering into a contract, by fulfilling all the essentials of the contract, they can create legal rights and legal obligations endorsed by the law. So both are civil wrongs. There are difference. So duty primarily fixed by the law, but contractually duty fixed by the parties. So that is only the difference between. Duty towards person generally torts, but contractually say both contracting parties and contracting party. If A and B are entered into contract, A owes duty towards B, B owes duty towards A. That's all. Say third person considered as a stranger. Contract. Third person who are not a party to the contract will be called as stranger. All exceptions privity of contract on the contract. Duty towards the parties each other. Torts mental element. ನಿಮಗೆ in entire ಇವಾಗ Indian Penal Code several enactments, ಯಾವುದೇ criminal side ಇರ್ಬೋದು, even civil sides actually, the intention is very, very important, mental element. So actus non facitrium nisi mensitria ಅದನ್ನೆಲ್ಲ ನೀವು ಈ ನೆಕ್ಸ್ಟ್ ಸ್ಲೈಡ್ ಅಲ್ಲಿ ತೋರಿಸ್ತೀನಿ. Actus non facitrium nisi mensitria. Act alone will not constitute crime. There must be intention. There are many times we commit a wrong without any intentions. The entire Indian Penal Code are two category. One is with intention, another without intention. So ನಿಮಗೆ section 299 and 300 ಅದರಲ್ಲೇ ಗೊತ್ತಾಗುತ್ತೆ intention, how it varies ಅಂತ. Culpable homicide without intention, culpable homicide with mens rea, that is murder ಅಂತ. And differentiate that. Intention oftenly considered. If, for example, defamation, assault, ಈ ತರ ಎಲ್ಲ malicious prosecution, ಈ ತರ ಎಲ್ಲ ಕೇಸ್ಗಳಲ್ಲಿ ನಾವು we considered what you call intention ಅಂತ ಹೇಳ್ತೀವಿ. Okay. Contract ಅಲ್ಲಿ intention is irrelevant. If you are really malicious, ಇವಾಗ ಯಾರ ಹತ್ರ ಸಾಲ ತಗೊಂಡಿದ್ದೀನಿ, ಸಾಲ ಕೊಡಲ್ಲ ಅಂತ ನಿರ್ಧಾರ ಮಾಡಿ ಸಾಲ ತಗೊಂಡಿದ್ದೀನಿ, ಅದು ಹೇಗಾಗುತ್ತೆ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಅದು. ಸೊ intention may be there, but we will claim the value of the contract. ಅಷ್ಟೇನೇನಿಲ್ಲ. ಅದರಿಂದ ಇಂಟೆನ್ಷನ್ ಇದ್ರು ಒಂದೇ ಇಲ್ದಿರೋ ಒಂದೇ, ವಾಟ್ ಎವರ್ ಐ ಗೇವ್ ಆಕ್ಚುಲಿ ಯು ಗಿವ್ ಬ್ಯಾಕ್. what is the damage caused due to breach, you pay for that. So that ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ. ಹಾಗಾಗಿ ಇಂಟೆನ್ಷನ್ ಈಸ್ ಇರ್ರಿಲೆವೆಂಟ್ ಅಂತ ಹೇಳ್ತೀವಿ. ಸೊ ಇದು ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಡಿಫರೆನ್ಸ್ ಏನಂದ್ರೆ ಪ್ರಿವಿಟಿ ಈಸ್ ಇರ್ರಿಲೆವೆಂಟ್ ಇನ್ ಟಾರ್ಟ್ಸ್. ಯಾಕಂದ್ರೆ ಟಾರ್ಟ್ಸ್ ಡ್ಯೂಟಿ ಟುವರ್ಡ್ಸ್ ದ ಸೊಸೈಟಿ. ನಮ್ಗೆ ಟು whom ever we causes injury, say they are entitled to claim from me actually or from the defendant. Okay, fine. ಅದರಿಂದ privity is, what you mean by privity is one of the essential element, say in law of contracts. Privity of contract is relevant. That is a difference between tort and the contract. Privity of contract is ಏನ್ ಪ್ರಿನ್ಸಿಪಲ್ ಏನ್ ಹೇಳುತ್ತೆ, only party to the contract can sue. ಅಂದ್ರೆ contractual parties are entitled to sue, not a stranger. ಅಲ್ಲೇನ್ ಹೇಳ್ತೀವಿ, ಪ್ರಿನ್ಸಿಪಲ್ ಹೇಳುತ್ತೆ stranger has no right to file a case against the parties. ಯಾಕಂದ್ರೆ ಅವನು neither a party to the contract, not even a beneficiary, of course, not even a beneficiary. So privity of contract, one exception created, that say if the two parties are actually conferring benefit to the third person, the beneficiary, in case breach, beneficiary can take action. If, for example, I agreed to pay 50,000 rupees and another person agreed to pay 50,000 on the occasion of marriage of C ಮದುವೆ ಮಾಡ್ಕೊತಾ ಇದ್ದಾರೆ, ಮದುವೆ ದಿನ ನಾನೊಂದು 50,000 ನೀನೊಂದು 50,000 ಕೊಡಪ್ಪ ಅಂತ ಹೇಳಿದೀವಿ. ಈಗ ಸಪೋಸ್ I paid 50,000 rupees, but other party refused to pay 50,000 rupees. So beneficiary can sue. This is an exception to the privity of contract, but not the stranger. So always look to the object of the contract. ಅದು ಯಾರಿಗೆ ಬೆನಿಫಿಟ್ ಆಗುತ್ತೆ, ಏನ್ ಆಬ್ಜೆಕ್ಟ್ ಅನ್ನೋದನ್ನ ನಾವು ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ಹಂಗಾಗಿ privity is very, very important to decide these issues. I'm saying that. So in a simple tort is also unliquidated, where person can claim unliquidated damages. Contract alli liquidated damages. That's the difference. Liquidated antandre value of the contract and depends upon the conditions of the contract. So the court cannot go beyond that and award the compensation, of course. But unliquidated damages, discretion. ಇಲ್ಲಿ ಕೆಲವೆಲ್ಲ ಓವರ್ಲ್ಯಾಪ್ ಆಗುತ್ತೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂಡ್ ಟಾರ್ಟ್ಸ್. ಅವಾಗ ಹೇಗೆ ಫೈಲ್ ಸೂಟ್ ಮಾಡ್ತೀರಾ ಅನ್ನೋದಕ್ಕೆ ಒಂದು ಎಕ್ಸಾಂಪಲ್ಸ್ ಅಷ್ಟೇ. ಡಾಕ್ಟರ್ ಅಂಡ್ ದ ಪೇಷಂಟ್. Suppose a father took his son, a minor son, to a doctor. Doctor advised him to go for an operation. Father accepted, gave consent. The doctor operated on his child negligently. For that, father can sue against doctor for breach of contract on behalf of minor, again sued for medical negligence. So ಇದು ಎರಡು ಆಗುತ್ತೆ ಅನ್ನೋದಷ್ಟೇ. breach of contract as well as so both they can claim compensation. ನೀವು ಹೇಗೆ ಕೇಳಬಹುದು, liquidated damages ಒಂದು ಕ್ಲೇಮ್ ಮಾಡಬೇಕು, ಇಲ್ಲಿ ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಏನಿಲ್ಲ. The agreement between the father and the doctor is that only has given a consent for the safe operation, that's contract. Okay, fees ಕೊಡಬಹುದು, ಅದೆಲ್ಲ fees is actually the value of the contract ಅಂತ ನೀವು ಹೇಳ್ಬೋದು. But negligent operation ಅದು again tortious liability ಆಗುತ್ತೆ. ಸರ್ for both ಅದು two different ಇದಾಗುತ್ತೆ. ಇದು ಓವರ್ಲ್ಯಾಪ್ ಆಯ್ತು ಅಂತ breach of contract as well as tortious liability ಓವರ್ಲ್ಯಾಪ್ ಆಯ್ತು ಅಂತ ಅನ್ನೋದನ್ನ ಒಂದು ಎಕ್ಸಾಂಪಲ್ಸ್ ಕೊಡ್ತಿದೀವಿ ಅಷ್ಟೇ. ಟಾರ್ಟ್ ಅಂಡ್ ಕ್ರೈಮ್ ಇವೆರಡಕ್ಕೂ ಇರೋ ವ್ಯತ್ಯಾಸ ಒಂದೇ, ದ ಸೀರಿಯಸ್ನೆಸ್ ಆಫ್ ದ ಅಂದ್ರೆ ನೇಚರ್ ಆಫ್ ರಾಂಗ್, ಆಕ್ಚುಲಿ ನೇಚರ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಒಂದು ಟಾರ್ಟ್ಸ್ ಅಲ್ಲಿ ಸಿಂಪಲ್ ಆಗಿ ಹೇಳಿದ್ವಿ ಸಿವಿಲ್ ರಾಂಗ್, ಬಟ್ ಅಟ್ ದ ಸೇಮ್ ಟೈಮ್ ಕ್ರೈಮ್ ಬಂದಾಗ ಪಬ್ಲಿಕ್ ರಾಂಗ್. We have to send a message to the society that say whoever commits a wrong against crime against individual, it should be treated as a crime against the society. ಹಂಗಾಗಿ ಇದನ್ನ ಪಬ್ಲಿಕ್ ರಾಂಗ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಿದ್ದೀವಿ. And also say what we require is a preventive measures. Preventive measures ಅಂದ್ರೆ the person who has committed a crime should not repeat it. ತಮಾಷೆ ಅನ್ಸುತ್ತೆ, ಯಾಕೆ ಹೇಳಿ, ರಿಫಾರ್ಮೇಟಿವ್ ಮೆಥಡ್ ಬಂದ್ಮೇಲೆ, ಜೈಲ್ ರಿಫಾರ್ಮ್ ಎಲ್ಲ ಬಂದ್ಮೇಲೆ, ನಿಮ್ಮ ಕಾನ್ಸೆಪ್ಟ್ ಗಳೆಲ್ಲ ಚೇಂಜ್ ಆದ್ಮೇಲೆ, ಏನು ಕ್ರೈಮ್ ಕಮಿಟ್ ಮಾಡಿದಂತ ವ್ಯಕ್ತಿನ ನೀವೇನಂತ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀರಾ? ಪೇಷಂಟ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀರಾ? ಜೈಲ್ನ ಹಾಸ್ಪಿಟಲ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀರಾ? ಜೈಲ್ ರಿಫಾರ್ಮ್ಸ್ ಬಗ್ಗೆ ನೆಲ್ಸನ್ ಮಂಡೇಲಾ ರೂಲ್ಸ್ ಮತ್ತೆ ಟೋಕಿಯೋ ರೂಲ್ಸ್, there are many provisions which speaks about the reform, facilities extended to the prisoner under trial ಮತ್ತೆ convicts ಬಂದಾಗ ಜೈಲ್ ರಿಫಾರ್ಮ್ ತುಂಬಾ ಆಗಿದೆ. ಸೊ ಫುಡ್ ಇಂದ ಹಿಡಿದು, ಹಾಸ್ಪಿಟಲ್ ಇಂದ ಹಿಡಿದು, ಅವ್ರದ್ದು ವೆದರ್ ಇದರಿಂದ ಹಿಡಿದು, ಆಮೇಲೆ ಅಕಾಮಿಡೇಷನ್, ಲೈಟ್ ಅಂಡ್ ಏರ್, ಆಮೇಲೆ ವರ್ಕ್ ಇರ್ಬೋದು, ಲಾಟ್ ಆಫ್ ಥಿಂಗ್ಸ್ ಆರ್ ದೇರ್. ಸೇ ಥ್ಯಾಂಕ್ಸ್ ಟು ನೆಲ್ಸನ್ ಮಂಡೇಲಾ ಹೂ ರೋಟ್ many things on jail reform, of course. Jail reform, humanitarian principles actually has given. Actually ಅದನ್ನೆಲ್ಲ ನೋಡಿದಾಗ ನಮಗೆ ಬಹಳ ಇದಾಗತ್ತೆ. ಅಂದಾಗ ಪಬ್ಲಿಕ್ ರಾಂಗ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ ನಾವು ಈ ಎಲ್ಲಾ ರಿಫಾರ್ಮೇಟಿವ್ ತಂದಾಗ, ವೇರ್ ಇಸ್ ದಿ ಫಿಯರ್ ಇನ್ ದ ಮೈಂಡ್ ಆಫ್ ಪೀಪಲ್ ಆಫ್ಟರ್ ಕಮಿಟಿಂಗ್ ದ ಕ್ರೈಮ್? ಬಿಫೋರ್ ಕಮಿಟಿಂಗ್ ದ ಕ್ರೈಮ್ ದೇರ್ ಮಸ್ಟ್ ಬಿ ಎ ಫಿಯರ್ ಆಫ್ ಲಾ, ಫಿಯರ್ ಆಫ್ ಪನಿಷ್ಮೆಂಟ್. ಆಸ್ಟಿನ್ ಅದಕ್ಕೆ ನೆನೆಸ್ಕೊತೀರ ನೀವು ಅಲ್ವಾ? ದೇರ್ ಮಸ್ಟ್ ಬಿ ಎ ಸ್ಯಾಂಕ್ಷನ್. ಆಸ್ಟಿನ್ ಸೋ ರಿಲೆವೆಂಟ್, whoever committed a barbaric or crimes and saying that ಆಸ್ಟಿನ್. ಈಗ ಸ್ಯಾಂಕ್ಷನ್ ಇರ್ಬೇಕು, ಸ್ಯಾಂಕ್ಷನ್ ಇದೆ ಸತ್ಯ, ಆದ್ರೆ ರಿಫಾರ್ಮೇಟಿವ್ ಮೆಥಡ್ ಇಂದ ಬಂದಾಗ the fear actually was reducing. No fear of punishment, no fear of sanction, ಅದೆಲ್ಲ ಆಗ್ತಾ ಇದೆ. ಓಕೆ, ಆದ್ರೆ ನೋಡಿ ಇವಾಗ ಸೇ ಡೆತ್ ಪೆನಾಲ್ಟಿ ಬಂದಾಗ ನಮಗೆ ವಿ ಡಿವೈಡೆಡ್, ಆಕ್ಚುಲಿ ಏನು ಡಿವೈಡ್ ಆಗ್ತಿರೋದು, ಹೇಗೆ ಡಿವೈಡ್ ಆಗ್ತಿದೀವಿ ಹೇಳಿ? ಡೆತ್ ಪೆನಾಲ್ಟಿ ಶುಡ್ ಬಿ ಡನ್ ಅವೇ ಅಂತ all Christian states ಅಥವಾ ವೆಸ್ಟರ್ನ್ ಸ್ಟೇಟ್ಸ್, they said there are many countries done away with death penalty. Still India and many countries in the world actually still keeping the death penalty. The question raised in many international forums, why you are keeping? You always claim that I am a champion of non-aligned movement, etc., Gandhian land, say a spirit of toleration, etc., but still you are keeping death penalty in your country. But now kotta uttara enu antandre, still we are keeping because we have to send a message, say there must be a fear of death, of course, death penalty bandaga. Adre nam justification enu antandre, we have taken this as a last resort, exceptional case idag matra death penalty tagtivi. Yavag ಮಾಡ್ತೀವಿ ನಾವು? The rarest of rare cases ಅಲ್ಲಿ ನಾವು we impose death penalty. Not all cases, not all murders, not all rapes. Say after Nirbhaya case, it was branded as a rapist country. Okay, fine, leave it. But death penalty, ಅದನ್ನ ಪನಿಷ್ಮೆಂಟ್ ಬಂದಾಗ ಅದಕ್ಕೆ ಪಬ್ಲಿಕ್ ರಾಂಗ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದೀವಿ. ಸೊ ದೇರ್ ಮಸ್ಟ್ ಬಿ ಎ ಫಿಯರ್ ಇನ್ ದ ಮೈಂಡ್ ಅಂತ ಹೇಳ್ತೀವಿ. ದೆನ್ ಕ್ರೈಮ್ ರೇಟ್ ಒಂದು ಕಂಪ್ಯಾರಿಟಿವ್ ಸ್ಟಡಿನೂ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಸೊ ವಾಟ್ ಇಸ್ ದ ಕ್ರೈಮ್ ರೇಟ್ ಇನ್ ವೆಸ್ಟರ್ನ್ ಕಂಟ್ರೀಸ್ ಅಂಡ್ ಇಂಡಿಯಾ, ಅಮೆರಿಕಾ, India, UK and India, of course, or any European countries and India, I'm saying. How because you adopted, you have removed the death penalty. Your all punishment class reformative methods, we also adopted that actually. And what is the crime rate? The fear that the citizen should live in peace without fear of any threat to his life and to his property. It is a responsibility of the government to maintain law and order, to prevent these things. So one such area bandaga political again maatadtila nanu, say no terrorist activities like that etc. ಏನು ಹೇಳ್ತಾ ಹೋಗ್ತಿರ್ತಾರೆ, ಅದನ್ನ ಇಲ್ಲಿ ತರಕ್ ಹೋಗಲ್ಲ ನಾನು. ಪಬ್ಲಿಕ್ ರಾಂಗ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾಗ ದೇರ್ ಆರ್ ಮೆನಿ ವ್ಯೂಸ್ ಟೇಕನ್, ಆಫ್ ಕೋರ್ಸ್. ಅದನ್ನ ಮಾಡಿದ್ದಾರೆ. ಈಗ ಟಾಟ್ಸ್ ಅಲ್ಲಿ ಏನು ಡ್ಯೂಟಿ ಪ್ರೈಮರಿ ಫಿಕ್ಸ್ ಬೈದಲ್ಲ, ಯು ನೋ ದಟ್ ಡ್ಯೂಟಿ ಅದನ್ನು ಸಹ ಫಿಕ್ಸ್ ಬೈದಲ್ಲ. ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡ್ ವಿ ಹ್ಯಾವ್, ಅದರಿಂದ ಇಟ್ಸ್ ನಾಟ್ ಎ ದೇರ್ ಇಸ್ ನೋ ಡಿಫರೆನ್ಸ್, ಆಫ್ ಕೋರ್ಸ್. ಬೋತ್ ಆರ್ ಲೀಗಲ್. Duty, of course. Towards duty towards the person generally, ಇದು ಅಷ್ಟೇ. Duty towards the society, crime, it makes no difference. So ಅಲ್ಲೂ ಏನ್ ಡಿಫರೆನ್ಸ್ ಇದೆ. ಮೆನ್ಸ್ರಿಯಾ ಆಫನ್ಲಿ ಕನ್ಸಿಡರ್ಡ್ ಎಲ್ಲಿ ಟಾಟ್ಸ್ ಅಂದ್ರೆ ಇಂಟೆನ್ಷನ್, ಮೆನ್ಸ್ರಿಯಾ ಅನ್ನೋ ಪದ ಏನು ಯೂಸ್ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ, ಬಟ್ ಇಂಟೆನ್ಷನ್ ಆಫನ್ಲಿ ಕನ್ಸಿಡರ್ಡ್ ಇನ್ ಟಾಟ್ಸ್. ಬಟ್ ಮೆನ್ಸ್ರಿಯಾ, ದಟ್ ವರ್ಡ್ is required, is relevant in all cases actually. Actus non facitrium nisi mensitria. Act alone will not constitute crime. There must be intention. Okay. Adana ನೀವು entire Indian Penal Code ಓದುವಾಗ, so the course teacher actually was explained the degree of mens rea, the absence of mens rea, the presence of mens rea. So all these things. So idanella taking into consideration the entire circumstances, the court determine the quantum of punishment. ಈಗೆಲ್ಲ ನೋಡಿ, ಒಂದಿನ ಏನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತೆ, ಇನ್ನೊಂದಿನ ಪನಿಷ್ಮೆಂಟ್, ಒಂದೇ ದಿನ ಪನಿಷ್ಮೆಂಟ್ ಅವಾರ್ಡ್ ಮಾಡಲ್ಲ. ಒಂದಿನ ಏನೋ ಹೇಳ್ತಾರೆ ವೆದರ್ ಈಸ್ ಗಿಲ್ಟಿ ಆರ್ ನಾಟ್, ನೆಕ್ಸ್ಟ್ ಡೇ ಇನ್ನೊಂದ್ ದಿನ ಮಾಡ್ತಾರೆ. ನಂಗೆ ಐ ಡೋಂಟ್ ನೋ ಅಬೌಟ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್. ಯಾಕಂದ್ರೆ ವೈ ದೇ ಆರ್ ಡೂಯಿಂಗ್ ಲೈಕ್ ದಟ್ ಅಂತ ಅನ್ನೋದು. ಎರಡೆರಡು ದಿನ ಯಾಕೆ ತಗೋತಾರೆ, ಒಂದೇ ದಿನ ಯಾಕೆ ತಗೊಳಲ್ಲ, ದಟ್ಸ್ ಇಟ್ಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ಇದು ಡಿಬೇಟ್ ಅದು. ಓಕೆ, ಮೆನ್ಸಿ ಆಫನ್ಲಿ ಕನ್ಸಿಡರ್. ಅದರಿಂದ ಇಂಡಿಯನ್ ಕ್ರೈಮ್ ಅಲ್ಲಿ, ಸೊ ವಿತೌಟ್ ಇಂಟೆನ್ಷನ್ ದೇರ್ ಇಸ್ ನೋ ಕ್ರೈಮ್ ಅನ್ನೋದು. ಅಂದ್ರೆ ಇದೇ ಕ್ರೈಮ್ ಆಗುತ್ತೆ, ಬಟ್ ಮೆನ್ಸ್ ರಿಯಾ ಪ್ಲೇ ಇಂಪಾರ್ಟೆಂಟ್ ರೋಲ್. ಗೊತ್ತಾಯ್ತಾ? ಅನ್ಲಿಕ್ವಿಡೇಟೆಡ್ ಡ್ಯಾಮೇಜಸ್ ಟಾಟ್ಸ್ ಅಲ್ಲಿ ಕ್ರೈಮ್, ಪನಿಷ್ಮೆಂಟ್ ಅಂಡ್ ಫೈನ್. ನಾನು ಅದನ್ನೇ ಹೇಳ್ತಿದ್ದಲ್ಲ, ಫೈನ್ ಅಂತ ಬಂದಾಗ ಸೇ ನಿಮ್ಗೆ CRPC ಇದೆ, ಹಂಗಾಗಿ ಯೂಸ್ ದಿ CRPC and try to give some quantum of compensation. ಅನ್ನೋ ಪದನ ಅಲ್ಲಿ ಯೂಸ್ ಮಾಡ್ಬೇಕು ಬಿಡೋ ಗೊತ್ತಿಲ್ಲ. You're imposing fine. Say the fine should be, the quantum of fine should be very high and the same amount should go to the victim, of course. ಹೋಗ್ಬೇಕು ಅವ್ರಿಗೆ. ಅದನ್ನ ಕೊಡ್ತಿದ್ದಾನೆ ಕೆಲವು ಕೇಸ್ಗಳಲ್ಲಿ. ಇದನ್ನ ಒಂದು ಸ್ವಲ್ಪ to increase that punishment. ಅಂದ್ರೆ ನಾವು because of the reformative that is ready to go to jail. ಜೈಲಲ್ಲಿ ಇರ್ತೀನಿ ಬಿಡ್ರಿ ಅಂತ ಈಗ ಹೇಳ್ತಾರೆ ಎಲ್ರೂ ಒಂಥರ. ಅದೊಂದು ಸೆಕೆಂಡ್ ಹೋಮ್ ಫಾರ್ ದೆಮ್ ಆಕ್ಚುಲಿ. ನಮ್ಮ ಮನೆಗಿಂತನೂ ಚೆನ್ನಾಗಿದೆ. ಫುಡ್ಸ್ ಆರ್ ಏನೋ, ಅದರಲ್ಲೂ ನ್ಯೂಟ್ರಿಷಿಯಸ್ ಫುಡ್, ಅದೆಲ್ಲ ಏನೇನೋ ಇದೆ ಬಿಡಿ. ಜೈಲ್ ವಿಸಿಟ್ ಮಾಡಿದಾಗ್ಲೇ ಗೊತ್ತಾಗುತ್ತೆ ನಮ್ಗೆ. ಹಂಗಾಗಿ ಇವರೆಲ್ಲ ಇಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದಾರೆ. ನೀವೇನೋ ಸ್ವಲ್ಪ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ಡ್ ಎಕ್ಸೆಟ್ರಾ ಆದ್ರೆ ಪನಿಷ್ಮೆಂಟ್ ಅಂತ ಕರಿಬೇಕು, ಇಲ್ಲ ಲೈಕ್ ಎ ವಿಸಿಟ್ ಟು ಸೆಕೆಂಡ್ ಹೋಮ್ ಅಂತ ಕರಿಬೇಕೋ ಗೊತ್ತಿಲ್ಲ. ಬಿಕಾಸ್ ಮೆನಿ ಪೀಪಲ್ ಆಫ್ಟರ್ ಗೋಯಿಂಗ್ ದೇರ್ ದೇ ಕಂಟಿನ್ಯೂ ಟು ಕಮಿಟ್, ಅಂದ್ರೆ ಹ್ಯಾಬಿಚುವಲ್ ಅಫೆಂಡರ್ಸ್ ಆಗ್ತಾರೆ. ದೇರ್ ಇಸ್ ನೋ ಫಿಯರ್ ಆಫ್ ದಟ್ ಒನ್. ಸೊ ದ ಸಿಸ್ಟಮ್ ಇಸ್ ಲೈಕ್ ದಟ್. ಈಗೆಲ್ಲ ಪ್ರೆಸೆಂಟ್ ಇದರಲ್ಲಿ ಗೊತ್ತಾಯ್ತಲ್ಲ, ಈಗೆಲ್ಲ ABCD ಕ್ಯಾಟಗರಿನೂ ಮಾಡ್ಕೊಂಡಿದೀವಲ್ಲ. ಸೊ ಪನಿಷ್ಮೆಂಟ್, ಅನ್ಲಿಕ್ವಿಡೇಟೆಡ್ ಡ್ಯಾಮೇಜಸ್ is a punishment and fine. Punishment, rigorous, simple, ಅದೆಲ್ಲ ಇದೆ. That depends upon the case. ನಾವೆಲ್ಲ ವಿಸಿಟ್ ಮಾಡಿದೀವಿ. ರಿಗರಸ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಸೀನ್ ಎನಿಥಿಂಗ್, ಆಫ್ ಕೋರ್ಸ್. ಸೊ ಆಲ್ ಲುಕ್ಸ್ ಲೈಕ್ ಸಿಂಪಲ್ imprisonment. Adana specifically the judge just mentioned that the nature of punishment that, but the difference matra ನಾವು ಇಲ್ಲಿ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ಬಟ್ ನಾನು ಬೇರೆ ರೆಫರೆನ್ಸ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಬಟ್ ಟಾರ್ಟ್ಸ್ ಅಂಡ್ ಕ್ರೈಮ್ ಓವರ್ಲ್ಯಾಪ್ ಆಗುತ್ತೆ ಅಂತ ಆಗ್ಲೇ ಹೇಳಿದೆ, ಬಿಗಿನಿಂಗ್ ಅಲ್ಲೇ ಹೇಳ್ತೇನೆ. ಡಿಫಮೇಷನ್, ಅಸಾಲ್ಟ್, ನೆಗ್ಲಿಜೆನ್ಸ್, ಫ್ರಾಡ್, ಇವೆಲ್ಲ ಮ್ಯಾಲಿಸಿಯಸ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇದೆಲ್ಲ ಓವರ್ಲ್ಯಾಪ್ ಆಗುತ್ತೆ. ಅದರಿಂದ the people always choose to go to criminal court rather than civil court, of course. If few cases actually the court starts awarding the handsome compensation, then people will turn this side because they want money, of course. ಹಂಗಾಗಿ ಅದು ಮಾಡಬೇಕು ಅಂತ ಅಷ್ಟೇ, ಏನಿಲ್ಲ. ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಏರಿಯಾ ಆಕ್ಚುಲಿ ಇಸ್ ಎಸೆನ್ಷಿಯಲ್ಸ್ ಆಫ್ ಟಾರ್ಟ್ಸ್. ಆ ಡೆಫಿನೇಷನ್ಗೆ ಎಸೆನ್ಷಿಯಲ್ಸ್ ಬೇರೆ. ಈಗ ಟು ಕಮಿಟ್ ಟಾರ್ಟ್ಸ್ ಇಸ್ ಲಯಬಿಲಿಟಿ, the following two essentials are required to be proved by the plaintiff. ವಾದಿ ಅದನ್ನ ಪ್ರೂವ್ ಮಾಡಬೇಕು ಎರಡನ್ನೂ ಅಂತ ಅನ್ಕೊಂಡೆ. ಸೊ ಒನ್ ಇಸ್ ಆಕ್ಟ್ ಆರ್ ಒಮಿಷನ್, ರಾಂಗ್ಫುಲ್ ಆಕ್ಟ್ ಆರ್ ರಾಂಗ್ಫುಲ್ ಒಮಿಷನ್ ಅಂತ ಹೇಳ್ತೀವಿ. ರಾಂಗ್ಫುಲ್ ಆಕ್ಟ್ ಆರ್ ರಾಂಗ್ಫುಲ್ ಒಮಿಷನ್. Understand the law expects the individual to do certain things and also not to do. ಕೆಲವನ್ನ ಮಾಡು ಅಂತ ಹೇಳ್ತದೆ, ಕೆಲವನ್ನ ಮಾಡಬಾರ್ದು. ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ನಾಟ್ ಟು ಡ್ರೈವ್ recklessly, drunken driving, etc. You have to take care, reasonable care in many circumstances. ಏನ್ ಹೇಳ್ತಾರೆ? ಮಾಡು ಅಂತ ಹೇಳ್ತಾರೆ. You have to take care ಅಂತ. ಬೇಡ ಅಂದ್ರೆ drunken driving prohibited. ಗೊತ್ತಾಯ್ತಾರೆ? ಕೆಲವು ಸಾರಿ ನಾವೇನ್ ಹೇಳ್ತೀವಿ, whenever the law says that you should not do this, say if he positively does that act, liability arises. ಹಾಗೆ omission to do that, actually omission to do that is also attracts, of course. ಅದಕ್ಕೆ ಕೆಲವು ಕೇಸ್ ತಗಳೆಲ್ಲ ಹೇಳ್ತೀನಿ. So first essential, wrongful act and the wrongful omission, of course. So law prohibits both, positive as well as negative. Omission, omitted to do that. You have to take care, andre not taken care, omitted. You have to pay somewhere the fees or something else, say you're omitted to do that. ಆ ಥರ ಎಲ್ಲಿ ಕೆಲಸ ಇದು ಮಾಡಬೇಕು ಅದನ್ನ ಡ್ಯೂಟಿ ಅಲ್ಲಿ ಮಾಡಲ್ಲ. ನೆಕ್ಸ್ಟ್ ರಾಂಗ್ಫುಲ್ ಆಕ್ಟ್ ಬಂದಾಗ ಏನ್ ಮಾಡ್ತಾರೆ? ಸಿ ಈಗ ನಾಟ್ ಫಾಲೋಯಿಂಗ್ ದಿ ಟ್ರಾಫಿಕ್ ರೂಲ್ಸ್, ದ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಒಮಿಷನ್ ಆಗುತ್ತೆ. ಇಲ್ಲಿ ಲೀಗಲ್ ಡ್ಯೂಟಿ ಟು ಟೇಕ್ ಕೇರ್ ಬಂದಾಗ. ಈ ರಾಂಗ್ಫುಲ್ ಆಕ್ಟ್ ಅಂದ್ರೆ ನಾಟ್ ಟು ಕಮಿಟ್ ಅನ್ ಅಸಾಲ್ಟ್, ಡಿಫಮೇಷನ್, ಬ್ಯಾಟ್ರಿ, ಎಕ್ಸೆಟ್ರಾ ಇವನ್ನೆಲ್ಲ ರಾಂಗ್ಫುಲ್ ಆಕ್ಟ್ಸ್ ಅಂತ ಹೇಳ್ತೀವಿ. ಗೊತ್ತಾಯ್ತು? ಸೊ ಇದನ್ನ ಒಂದು ಎಸೆನ್ಷಿಯಲ್ಸ್ ನ plaintiff has to prove before the court of law. ಎರಡನೇದು ಲೀಗಲ್ ಡ್ಯಾಮೇಜ್ ಅಂತ. ಲೀಗಲ್ ಡ್ಯೂಟಿ ಇದ್ದಾಗ ದ ನೆಕ್ಸ್ಟ್ ಥಿಂಗ್ ಇಸ್ ಆಕ್ಚುಲಿ ಇಸ್ ಎ ಲೀಗಲ್ ಡ್ಯಾಮೇಜ್. ಲೀಗಲ್ ಡ್ಯಾಮೇಜ್ ಇಲ್ಲಿ ವರ್ಡ್ ಒಂದು ನಾವೇನ್ ಕರಿತೀವಿ ಇಂಜೂರಿಯಾ. ಇಂಜೂರಿಯಾ ಇಸ್ ಆಕ್ಚುಲಿ ಲ್ಯಾಟಿನ್ ವರ್ಡ್. ಇಟ್ ಮೀನ್ಸ್ ಇಂಜೂರಿಯಾ ಮೀನ್ಸ್ ವೈಲೇಷನ್ ಆಫ್ ಲೀಗಲ್ ರೈಟ್. ಅಂದ್ರೆ ಇಂಜೂರಿಯಾ ಅಂದ್ರೆ ಇಂಜುರಿ ಆಫ್ ವಾಟ್ ಅಂತ ಅಂದ್ರೆ ಇಲ್ಲಿ ಎರಡು ತರ ಬರುತ್ತೆ. ಡ್ಯಾಮೇಜಸ್, ಇಂಜುರಿ, ಡ್ಯಾಮೇಜ್ ಈ ತರ ಎಲ್ಲ ಹೇಳ್ತಿರ್ತೀವಿ. ಸೇ ಬಾಡಿಲಿ ಇಂಜುರಿನೂ ಆಗುತ್ತೆ, ಡ್ಯಾಮೇಜ್ ಟು ಪ್ರಾಪರ್ಟಿ ತರನೂ ಆಗುತ್ತೆ. ಬಟ್ ವಿ ಯೂಸ್ ದ ವರ್ಡ್ ಲೀಗಲ್ ಡ್ಯಾಮೇಜ್. ಲೀಗಲ್ ಡ್ಯಾಮೇಜ್ ಅಲ್ಲಿ ನಾರ್ಮಲಿ only one recognized, that is injuria sine damnum injuria, damnum sine injuria, of course. ಇಲ್ಲಿ ಒಂದೇನ್ ಹೇಳ್ತಾರೆ, there must be some act or omission on the part of the defendant. Act means wrongful act which is prohibited by the law. A person have done some act which he was not expected to do. ಅದೇ ಈಗ explain ಮಾಡಿದ್ನಲ್ಲ, ಅದನ್ನೇ same thing actually is not to defame, assault or trespass. Omission ಗೆ ನಾವು we have two case laws actually, Glasgow Corporation Taylor, Municipal Corporation of Taylor. In both Glasgow Corporation, you are aware that they have grown a poisonous tree and a boy of 7-year-old attracted and ate it, plucked and ate it, say, and died due to poisonousness. Or ಏನು negligence ಮಾಡಿದ್ರು, they are not fence the tree and also not fix the notice board. ಒಂದು ಫಲಕ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಬೇಲಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, where preventing is a public place. Children were mischievous and not aware of these things, and that's why growing itself is a recital of error. Adre avatan dina say the law is not developed so much. They have grown an ornamental, a beautiful tree, say in the park, public park, but this is what happened. So liability was fixed in 1922, for their negligence. Municipal Corporation of Delhi, an Indian case where in the Chandni Chowk, a clock tower fell down and some people who were sat below that died. Okay, when it was fell down, it was 80-year-old. Chandni Chowk, ನೋಡಿರ್ಬೋದು ಆ ಒಂದು clock tower ಬಿದ್ದೋಗುತ್ತೆ. It was 80-year-old. So when the committee was constituted and inquired, say what exactly the life of the clock tower, ಯಾವುದೇ ಸ್ಟ್ರಕ್ಚರ್ ಆದ್ರಿ ಅದ್ರ ಲೈಫ್ ನ ಒಂದು ಡಿಟರ್ಮೈನ್ ಮಾಡಿರ್ಬೇಕು. ಗೊತ್ತಾಯ್ತಲ್ಲ, the material used to construct the clock tower was only 40 to 45 years. our material ಎಲ್ಲ ನೋಡಿದಾಗ ಅದು ಅಷ್ಟೇ ಅನ್ಸುದು, 40 to 45 years. But it was fell down, it was 80-year-old. Andre 45 years ಇಂದ up to 80. So they have not repaired it, not demolished it. ಏನಿಲ್ಲ, no corrective measures was taken. So they were negligent. The presence of clock tower after 45 years, say, was itself is a negligence on the part of the municipal corporation or responsibility to maintain it. Say, Swaganti's husband who died in that incident claimed the compensation. The court said, yes, they are omitted to take care of the clock tower. These two are very important. Legal damage. Legal damage, there are two types of damages: injurious sign damno and damnum sign injuria. Fingertips case injurious sign damno, injury without damage. There is a violation of legal right without damage. Physical damage injury to body agila, injury damage to property agila, but only thing is legal right violated. When there is a legal right violated, remedy obviously recognized. So very famous case was the Ashby versus White. You all heard and very familiar that in a parliamentary election, the returning officer refused to accept the vote of Ashby, say, and prevented from exercising his franchise. To whom he was intended to vote, that candidate won by majority. E point important. Won by majority. From this vote, Ashby's vote, no damage caused. No damage caused. This candidate not lost. He has one thumping majority, of course. So still he filed a case. ನನಗೆ ಪ್ರಶ್ನೆ ಈಗ ನೀವೆಲ್ಲರೂ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕಾಗಿರೋದು, when there is no damage, say when he approached the court of law, what should be the argument? He says that my legal right violated. Okay, fine, violated. What exactly the damage? No damage. This candidate won. No damage actually. So what is the duty of the court now? When there is no damage, nothing has happened to him, only his legal right, constitutional right, otherwise political right violated. What should be the quantum of compensation? Because the duty of the court here is to recognize the legal right of the Ashby. Damage immaterial, quantum of compensation immaterial. Hence, the court awarded nominal damage. The object of awarding nominal damage is to recognize the legal right of Ashby. Why it become very famous? Our John Holt, he says that every damage, every injury actually results in damage. Right? Every injury imports a damage, though it does not cost the party one farthing. One penny no damage agilla, okay? But still is entitled in the sense right to justify one, and it is a court decided what type of compensation should be given. Nominal damage. Nominal damage. Damage is immaterial. Say the legal right very important. Adike ubi jessibi remedium bandantadella. Okay, 1703 nalli. So we 16th century admele say we recognize the ubi just ibi remedium. Where there is a right, there is a remedy, of course. Constantine versus Imperial Hotels Limited. ಇದೆಲ್ಲ ನಿಮ್ಗೆಲ್ಲ ಗೊತ್ತು. West Indian cricket team visited UK and they are playing test cricket. Constantine, a West Indian test cricketer, visited Imperial Hotels Limited and sought accommodation. But even though the rooms are available, the authorities were refused to give accommodation. But Constantine, he was a cultural ambassador of West Indies. He is representing sovereign, cultural ambassador ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. So what they did actually was wrong. He is ready to fulfill the conditions of the hotel, but they said, we are ready to accommodate you in the outskirts of London. ಹೊರಗಡೆ ಹೋಗಿ ಬೇಕಾದ್ರೆ ಅಲ್ಲಿರಪ್ಪ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. But he is not ready, of course. He filed a case. There are also nominal damages, right to seek accommodation. ನೀವೆಲ್ಲ ಹೇಳ್ತಿರ್ತೀರ ಅಡ್ಮಿಷನ್ಸ್ ರಿಸರ್ವ್ಡ್ ಅಂತ ಹೇಳ್ತಿರ್ತಾರೆ, ಹೋಟೆಲ್ಗಳೆಲ್ಲ ಹಾಕೊಂಡಿರ್ತಾರೆ, ಇಷ್ಟ ಇದ್ರೆ ಕೊಡ್ಬೋದು, ಇಷ್ಟ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ. ಇಲ್ಲಿ ಪ್ರಾಬಬಲಿ ಒನ್ ರೀಸನ್ ಅಟ್ ದಟ್ ಟೈಮ್ 1940s is that apartheid policy. Apartheid policy ಇದ್ರೆ why you are playing cricket? Sorry, West Indies ಏನಿಲ್ಲ, because of South Africa ತಾನೆ, South Africaಗೆ apartheid policy. But ಅದೇ ಕಲರ್ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಅದು ಇದ್ದೇ ಇತ್ತಲ್ಲ, ಹಂಗಾಗಿ they were ruling South Africa at that time. ಇದೆಲ್ಲ ಗೊತ್ತಲ್ಲ ನಿಮಗೆ. ಸೊ ಹಂಗಾಗಿ ಬಟ್ ವಾಟ್ ಇಟ್ ಮೇ ಬಿ, Constantine filed a case and they said you have a duty to give accommodation because he is ready to fulfill the conditions actually. Nominal damage again. But Indian case ಬಂದಾಗ ನಿಮಗೆ ಇದೆಲ್ಲ very familiar. Beam Singh versus state of Jammu and Kashmir. At that time he was an MLA and when he was going towards assembly to attend, say he was arrested and illegally kept behind the bar nearly 14 hours and immediately they went to court by way of writ of habeas corpus and he was released within 14 hours and but the court awarded 50,000 rupees. 1986 ಅಲ್ಲಿ 50,000 rupees simply considered as aggravated damages. ಆ ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ಬಿಡುತ್ತೆ, ಅದನ್ನ ಅಗ್ರವೇಟ್ ಹಾಕ್ಬೇಕೋ ಎಕ್ಸಾಂಪ್ಲರಿಗೆ ಹಾಕ್ಬೇಕು ಅಂತ ಗೊತ್ತಾಯ್ತಲ್ಲ. ಅಗ್ರವೇಟೆಡ್ ಡ್ಯಾಮೇಜ್ ಅಂದ್ರೆ ಮೋರ್ ದೆನ್ ವಾಟ್ ಹಿ ಹ್ಯಾಸ್ ಸಫರ್ಡ್ ಅಟ್ ದಟ್ ಟೈಮ್ ಗೊತ್ತಾಯ್ತಲ್ಲ. 86 ಅಲ್ಲಿ 50,000 rupees, ನಾಟ್ ಎ ಸ್ಮಾಲ್ ಅಮೌಂಟ್. ಸೇ ಬಟ್ ಬಿಕಾಸ್ ಹಿ ವಾಸ್ ಎ ರೆಪ್ಯೂಟೆಡ್ ಪರ್ಸನಾಲಿಟಿ, ಆಫ್ ಕೋರ್ಸ್, ಅಂದ್ರೆ MLA ಆಗಿದ್ದ ಒಂದೇ ಕಾರಣಕ್ಕೆ. This is injuria sign. Damage sign injuria, damage without injury. Andre there is no violation of legal right, but there is a damage. ನಷ್ಟ ಉಂಟಾಗಿರುತ್ತೆ, ಆದ್ರೆ ಹಕ್ಕುಚ್ಯುತಿ ಆಗಿರಲ್ಲ. ಇದಕ್ಕೆಲ್ಲ ಫೇಮಸ್ ಕೇಸಸ್ ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. ಗ್ಲೌಸೆಸ್ಟರ್ ಗ್ರಾಮರ್ ಸ್ಕೂಲ್, ಮಗಲ್ ಸ್ಟೀರ್ಶಿಪ್ ಕಂಪನಿ, ಉಷಾ ಬೇನ್, ಚೆಸ್ಮೋರ್ ರಿಚರ್ಡ್ಸ್, ಬ್ರಾಡ್ಫೋರ್ಡ್ ಕಾರ್ಪೊರೇಷನ್ಸ್. We can give innumerable case laws, but these are all few recognized case laws. ನೀವು ಏನ್ ಬರೀತಿದ್ರು ಇವೆರಡು ಕೇಸ್ ಬರೀಬೇಕು. ಯಾವುದು ಡಾರ್ಕ್ ಮಾಡಿದೀನಿ ನೋಡಿ, ಯಾವುದು ಗ್ಲೌಸೆಸ್ಟರ್ ಗ್ರಾಮರ್ ಸ್ಕೂಲ್ ಕೇಸ್ ಅಂಡ್ ಬ್ರಾಡ್ಫೋರ್ಡ್ ಕಾರ್ಪೊರೇಷನ್ ಮೇಯರ್ ಆಫ್ ವರ್ಸಸ್ ಪಿಕಲ್ಸ್, ಇವೆರಡು ಕೇಸನ್ನ ಬರೀಬೇಕು ಆಕ್ಚುಲಿ. ಮಿಕ್ಕದು ಎಷ್ಟೊಂದು ಬರೆಯಕ್ಕಾಗತ್ತೆ. ಇಟ್ ಇಸ್ ಅ ಕ್ವಶನ್ ಆಫ್ ಟೈಮ್. 3 hours ಅಲ್ಲಿ ನೀವು ಹ್ಯಾವ್ ಟು ಮೇಕ್ ಎ ಪ್ಲಾನ್ ದಟ್ ಹೌ ಮಚ್ ಯು ಹ್ಯಾವ್ ಟು ರೈಟ್ ಅಂಡ್ ಯು ಹ್ಯಾವ್ ಟು ರೈಟ್ ಆಲ್ ದ ಕ್ವಶನ್ಸ್. ದ ಕ್ವಶನ್ ಆಫ್ ಟೈಮ್. ನಾವು ಮೇಷ್ಗಳು ಹೇಳೋದೆಲ್ಲಾನು ನೀವು ಬರೆಯಕ್ಕಾಗಲ್ಲ, ಅಲ್ಲಿ ಬರೆದ್ರು ಇಲ್ಲ. ಬಟ್ ಹೇಗೆ ಬರೀಬೇಕು ಅಂದ್ರೆ, ಆಫ್ಟರ್ ರೈಟಿಂಗ್ ದ ಗ್ಲೌಸೆಸ್ಟರ್ ಗ್ರಾಮರ್ ಸ್ಕೂಲ್ ಕೇಸ್, ದ ಸಿಮಿಲರ್ ಡಿಸಿಷನ್ ವಾಸ್ ಅಪೆಲ್ಡ್ ಬಿಕಾಸ್ ದೇರ್ ಇಸ್ ನೋ ವೈಲೇಷನ್ ಆಫ್ ಲೀಗಲ್ ರೈಟ್ ಈವನ್ ಇನ್ ಮೊಘಲ್ ಸ್ಟೀರ್ಶಿಪ್ ಕಂಪನಿ, ಉಷಾ ಬೇನ್ ಕೇಸ್, ಚೆಸ್ಮೋರ್ ಕೇಸ್ ಅಂತ ಈ ತರ ಬರೆದು ಆಯ್ತು. ಯು ನೀಡ್ ನಾಟ್ ರೈಟ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದ ಕೇಸ್ ಅಂಡ್ ಓನ್ಲಿ ರೂಲಿಂಗ್ ಬರೆದ್ರೆ ಸಾಕು. ಏನ್ ವಾಟ್ ಎವರ್ ದ ರೂಲಿಂಗ್ ಮೇಡ್ ಇನ್ ದ ಗ್ಲೌಸೆಸ್ಟರ್ ಗ್ರಾಮರ್ ಸ್ಕೂಲ್ ಕೇಸ್, ದ ಸೇಮ್ extended to all the cases actually, because there is no violation of legal right. So when there is no legal violation of legal right, there is no remedy, of course, no remedy. Law and recognize. Say damage actually is actual, alva, is a fact, but still court not recognize the damage. Adanna alli nodta irthivi. Hangagi Gloucester grammar school alli there is a quarrel between a very famous teacher and the management, and he was from the school. So he was so angry. Adunu ಹೇಳಂಗಿಲ್ಲ. He opened a rivalry school in front of Gloucester grammar school case. ಅಲ್ಲಿ 40 pence ಇತ್ತು for 3 months per student. ಇಲ್ಲಿ he reduced to 20 pence for 3 months ಮಾಡಿದ. So all the students flocked towards new school. Anyhow, teacher was very famous, and fees also reduced, and hence all the students joined a new grammar school. And the old grammar school, Gloucestershire Grammar School, filed a case for causing huge damage. They are virtually, they had to close down the school. No, not even a single student was there to run the school. ಎಲ್ಲ ಮಕ್ಕಳು ಇಲ್ಲಿಗೆ ಬಂದರು ಅಂತ ಹೇಳ್ತಾರೆ. It's completely, they ಬಾಗ್ಲಾಕ್ಸ್ದ said door is closed. But the court said it is a competition. Both have rights. Even the teacher also has right, the freedom of profession, trade, business ಅಂತ ನಾವು 19 ಜಿನಲ್ಲಿ ಹೇಳ್ತೀವಲ್ಲ, ಹಾಗೆ he also has right to open a school. Rivalry school ಅಂತ ಹೇಳ್ತೀವಿ. What is his intention actually? Intention is to close the old school ಅಂತ ಇತ್ತು ಅದು. Whether you can take the presumption from that circumstances. Okay, fine. The court simply dismissed that. Even though there was a damage, they have not violated your legal right. You can run it. Loss or profit is not the question. It is only like a business. And a school na business antanu helakovala. But it's a competition, of course. Because nowadays we see provision stores, hospitals, theaters, schools, competitive nalli they are open and they are running actually. So everybody has right, and that's why there's no violation of legal right, of course. Usha Ben versus Bhaglakshmi Mughal Steamship Company, they are carrying tea trade between China and Europe. They reduced the freight charge because to prevent Mughal Ship Company from participating in this competition actually. Again, it is a competition, nothing can be done, your right not violated. Bhaglakshmi Chitra Mandir takes time, yakandre adu very interesting, and nimage alli nodbekagirodu ಏನಂದ್ರೆ the court refused to give a permanent injunction regarding the stay of what is that Usha Ben case alli Jai Santoshi Ma case adu, Jai Santoshi Ma. So alli ಹೇಳಿದ್ದು ಏನಂದ್ರೆ the director also has the freedom of speech and expression. Is a right to direct a film, of course, right to make a film. But the subject matter was fictitious, and the story fictitious. Hence, it is only an entertainment. People can come to public place and see the film, and we cannot prevent them because it is an entertainment. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಕಂಪೇರ್ ಮಾಡುವಾಗ ಅವಸ್ಥೆ ಫಿಲಮ್ ಹೇಳಿದೆ ನಾನು, ಶಾಂತವೇರಿ ಗೋಪಾಲ್ ಗೌಡದ್ದು ಹೇಳಿದೆ. ದ ಕೋರ್ಟ್ ಗೇವ್ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್. ಅದು ಒಂದು ವಾರ ಮಾತ್ರ ನಡೀತು, ಆಮೇಲೆ ಇದುವರೆಗೂ ಅದು ಚಿತ್ರ ಓಪನ್ ಆಗಿ again not shown in the film theater, of course. ಎಲ್ಲೂ ಬಿಡಲಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಇಟ್ಸ್ ಎ ವೈಲೇಷನ್ ಆಫ್ injury to the reputation of a person who lived and earned the reputation in the society. But these Lakshmi, Saraswati, Parvati, a fictitious goddesses, hence subject matter fictitious, and director has a freedom of speech and expression, and is a public, say they can it's only entertainment, and they can say we can't prevent the public from seeing the Santoshima film. Usha, if they have a belief over these goddesses, worship is your privacy, it is a personal right, and you can't impose your faith on public. ನಮ್ಮ ನಂಬಿಕೆಗಳನ್ನ ಇನ್ನೊಬ್ಬರ ಮೇಲೆ ಏರಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ, ಗೊತ್ತಾಯ್ತಲ್ವಾ? ಓಕೆ, ನನಗೆ ಚೆಸ್ಮೋರ್ ರಿಚರ್ಡ್ಸ್ ಬಿಡಿ, ಅದು ಇರೆಗ್ಯುಲರ್
ಮತ್ತೆ ಬರೋದಿಲ್ಲ, ಅವ್ರು ಚೆಕ್ ಮಾಡಲ್ಲ.
ಪ್ಲೀಸ್ ಮ್ಯೂಟ್ ಯುವರ್ ಮೈಕ್ ಸರ್,
ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಓಕೆ, ಚೆಸ್ಮೋರ್ ರಿಚರ್ಡ್ಸ್ ನಾವೇನು ಅಷ್ಟೊಂದು ಕಾನ್ಸಂಟ್ರೇಟ್ ಮಾಡಕ್ಕಲ್ಲ, ಬಟ್ there was an irregular channel appeared only during rainy seasons, and both are using as a neighbors planned. Say both are using that from last 60 years. 60 years actually will not give you the easementary right. because if it is a regular channel, then you will get a easement, right? If this is a irregular spring actually appears only in rainy season, and also he never obstructed the flow of water. But what he did was, Richard, he dug a well on his own land, and the water actually percolated to his well, and the spring ಅದು ಜರಿ ಏನಾಯ್ತು ಅದು destroy ಆಯ್ತು. That's why they filed the case. And they said no, he has every right to dig a well on his own land, in his own land, and he has not destroyed. And also it is not a regular channel. So ಹಂಗಾಗಿ ಅದನ್ನ ರೆಕಗ್ನೈಸ್ ಮಾಡಲಿಲ್ಲ. ಬ್ರಾಡ್ಫೋರ್ಡ್ ಕಾರ್ಪೊರೇಷನ್ಸ್ ಮೇಯರ್ ಪಿಕಲ್ಸ್ ಏನಿದೆ, ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಕೇಸ್. ಏನಂತಂದ್ರೆ the Bradford Corporation, they were drawing water from Pickles land where some shafts ಇರ್ತವೆ, ಹೊಂಡಗಳಿರ್ತವೆ, ನೀರಿನ ಹೊಂಡಗಳಿರ್ತವೆ. ಅದನ್ನ ಅವರು they were used to draw water so many years. Once Pickles asked them, buy my land, actually ತಗೊಂಬಿಡಿ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಅನ್ನ ಅಂತಾನೆ ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರೆ. They said ready to buy Pickles land because they want water from his land. So but Pickles he prescribed what you call exorbitant price. Aವಾಗ ಏನ್ ಮಾಡಿದ್ರು, Bradford Corporation refused to purchase the land. So he became very angry, maliciously he destroyed his own shops. ತನ್ನ ಭೂಮಿನಲ್ಲಿರೋ ಹೊಂಡಗಳನ್ನೆಲ್ಲ ಅವನೇ ಎಲ್ಲ ಹಾಳು ಮಾಡ್ಕೊಂಡ. Bradford Corporation said, from so many years we are drawing water from his land, so this man destroyed it and our right actually is violated. They said no easementary right. Every time when you draw water, it is maybe implied consent. Initially there may be express consent, and when it becomes continuous, there may be an implied consent from people and to draw water. So you never gets any easement right over it actually. But even though there is a maliciousness on the part of Pickles, the court refused to recognize because there is no violation of legal right, because he destroyed his own shops. ತನ್ನಲ್ಲಿರೋ ಹೊಂಡಗಳನ್ನ ಹಾಳು ಮಾಡ್ಕೊಂಡ ಅಂತ ಹೇಳ್ತಾರೆ. So this is ubi jus ibi remedium. That's exactly the conclusion. Every student, after writing injurious sign damnum sign injuria, they have to write the conclusion ubi jus ibi remedium. Where there is a right, there is a remedy. Andre recognize the injurious sign damnum, but not the damnum sign injuria. Mental element ಬಗ್ಗೆ ನಾನು ಮಚ್ ಐ ಡೋಂಟ್, ಯಾಕಂದ್ರೆ ಎಲ್ಲ ಚಾಪ್ಟರ್ಗಳನ್ನ ಓದುವಾಗ ನಾವು ಎರಡು ತರ ಕಾನ್ಸೆಪ್ಟ್ ಇಟ್ಕೊಂಡಿದ್ವಿ, fault theory and the no fault theory, of course. So there must be a wrong committed by the defendant, then only you can fix the responsibility. When he has not committed the wrong, you can't fix the responsibility. No fault liability la say the manner in which the court recognized is different. Whoever brings anything, when you are keeping in your premises, keep it intact. If it escapes and causes damage, you are responsible. ಏನಾದ್ರು ವಸ್ತು ತಂದು ಇಟ್ಕೊಂಡಿದ್ರೆ ಆ ವಸ್ತು ನಿಮ್ಮಲ್ಲೇ ಇರಬೇಕು ಅಥವಾ ನಿಮ್ ಜಾಗದಲ್ಲೇ ಇರಬೇಕು. ಎಸ್ಕೇಪ್ ಆಗಿ ಯಾರಿಗಾರು ತೊಂದರೆ ಆದ್ರೆ ಯು ಆರ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಅಂದ್ರೆ ಆ ತರ ತಗೊಂಡ್ರು. ಅದನ್ನ ನಾವೇನ್ ಹೇಳಿದ್ವಿ, ನೋ ಫಾಲ್ಟ್ ಲಯಬಿಲಿಟಿ. ಸೊ ಹೌ an object can escape from one place to another place ಅನ್ನೋದನ್ನ ನೋಡ್ಬೇಕು. ದೇರ್ ಮೇ ಬಿ ಸಮ್ ಪಾರ್ಟ್ ಆಫ್ ನೆಗ್ಲಿಜೆನ್ಸ್, ಅದನ್ನ ಸ್ಟ್ರಿಕ್ಟ್ ಲಯಬಿಲಿಟಿ ಹೇಳುವಾಗ ಹೇಳ್ತೀನಿ ನಾನು. ಸೊ fault when relevant, in many of the branches of law of trust like assault, battery, false imprisonment, fraud, or deceit, malicious prosecution, conspiracy, the state of mind of a person is relevant to ascertain the liability, of course. ಈ ತರ ಕೃತ್ಯಗಳನ್ನ ಮಾಡುವಾಗ ಉದ್ದೇಶ ದುರುದ್ದೇಶ ಎಲ್ಲ ಹೇಳ್ತಿರ್ತೀವಿ. the state of mind is equally important, of course. ಅದ್ರ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. liability without fault ನಾನು ಹೇಳಿದ್ನಲ್ಲ, ರೇನಸಸ್ ಫ್ಲೆಚರ್, ಅದನ್ನ ಪುನಃ ನಾನೇನು ಹೇಳಕ್ಕೋಲ್ಲ, ಹೇಳಿದೀನಿ. ಸೊ ಈ ತರ ಎಲ್ಲ ಬರ್ತಾರೆ. ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲೂ ನೀವು ಅದನ್ನೇ ಹೇಳ್ತಾ ಹೋಗ್ತಿರ್ತೀರ, ವೆದರ್ ಇಸ್ ಇಂಟೆನ್ಷನಲ್ ಆರ್ ಅನ್ಇಂಟೆನ್ಷನಲ್. ಯಾಕಂದ್ರೆ ನೆಗ್ಲಿಜೆನ್ಸ್ ಕೇಸಸ್, ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಆಕ್ಟ್ ಗಳಲ್ಲಿ ನಾವು ನೆಗ್ಲಿಜೆನ್ಸ್ ಅನ್ನೋದನ್ನ ತಗೋತೀವಿ, ಬಟ್ ಇಂಟೆನ್ಷನಲ್ ನಾಟ್. ಬಟ್ ವೆನ್ ಯು ಲುಕ್, ದೇರ್ ಆರ್ ಪೀಪಲ್ ಆಕ್ಚುಲಿ ಹೂ ಒಂಥರ ಆಕ್ಸಿಡೆಂಟ್ಸ್ ತರ ತೋರಿಸ್ತಾರೆ, ಬಟ್ ನಾಟ್ ಆಕ್ಸಿಡೆಂಟ್, ಇಟ್ ವಾಸ್ ದ ಮರ್ಡರ್ ಆಕ್ಟ್. ಈ ತರನೂ ಕೇಸ್ಗಳಿರ್ತವೆ. So aduna looking to the entire circumstances and collection of evidence, you can determine whether it is a murder or it is a purely an accident. ಗೊತ್ತಾಯ್ತಾನ, ಅದನ್ನೆಲ್ಲ ಹೇಳ್ತಾ ಹೋಗ್ತಿರ್ತೀವಿ. ಹಂಗಾಗಿ ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಅದನ್ನೆಲ್ಲ ಹೇಳ್ತೀವಿ. ಸೊ ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಈಗ ನೋ ಫಾಲ್ಟ್ ಲಯಬಿಲಿಟಿನ ಅಂದ್ರೆ ಸ್ಟ್ರಿಕ್ಟ್ ಲಯಬಿಲಿಟಿನ ನಾವು ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಲ್ವಾ. ಏನಂದ್ರೆ ಡೆತ್ ಆದಾಗ ಇಷ್ಟು ಕೊಡ್ಲೇಬೇಕು, ಈವನ್ ವಿತೌಟ್ ಪ್ರೂಫ್ ಆಫ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಫ್ ದಿ ಡಿಫೆಂಡೆಂಟ್ ಅನ್ನೋದನ್ನ ಹೇಳಿದ್ದಾರೆ. ಸೊ ದಟ್ ಈಸ್ ದೇರ್ ಆಲ್ವೇಸ್. ಸೊ ಟುಡೇ ವೆದರ್ ಈಸ್ ನೆಗ್ಲಿಜೆಂಟ್ ಆರ್ ನಾಟ್, ಇವಾಗಂತೂ ಇನ್ನೂ ಡೈಲ್ಯೂಟ್ ಮಾಡ್ತಿದ್ದಾರೆ. ಸಮ್ಟೈಮ್ಸ್ ಈಗ DL ಇಲ್ಲ ಅಂತ ಅಂದ್ರೂ ಕೊಡ್ಬೇಕು, ಅಥವಾ ಇನ್ನೇನೋ ಈ ತರ. ನೆಕ್ಸ್ಟ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಏನ್ ಮಾಡ್ಬೇಕು, ಇನ್ಶೂರೆನ್ಸ್ ಎಕ್ಸ್ಪೈರ್ ಆಗಿದ್ರೆ ಏನಾಗ್ಬೇಕು, ಈ ತರ ಒಂದ್ ಸ್ವಲ್ಪ ಲಿಬರಲ್ ಆಗಿ ಇವಾಗ ದೇ ಆರ್ ಸೀಯಿಂಗ್. ಬಿಕಾಸ್ ವಿಕ್ಟಿಮ್ ಅವರು ಅದರ್ವೈಸ್ ದೇರ್ ಇಸ್ ನೋ ಸೋಷಿಯಲ್ ಸೆಕ್ಯೂರಿಟಿ ಫಾರ್ ಹಿಮ್ ಆಕ್ಚುಲಿ. ಹಂಗಾಗಿ ಅದನ್ನ ಸ್ವಲ್ಪ ಡೈಲ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಸ್ಟ್ರಿಕ್ಟ್ ಲಯಬಿಲಿಟಿ ಇಂಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅಂಡ್ ಈವನ್ ಸಮ್ ಸ್ಲೈಟ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆನ್ ದ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಪ್ಲಾಂಟಿಫ್ ಅಥವಾ ಲೀಗಲ್ ಹೇರ್ಸ್ ಕ್ಯಾನ್ ಕ್ಲೈಮ್ ದ ಕಾಂಪನ್ಸೇಷನ್ ತರನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಸೊ ದಟ್ ಈಸ್ ಇಟ್ ಇಸ್ ಡಿಬೇಟೆಡ್ ವೆದರ್ ಇಸ್ ರೈಟ್ ಆರ್ ರಾಂಗ್, ಗೊತ್ತಾಯ್ತಲ್ವಾ. ಯಾಕಂದ್ರೆ DL ಇಲ್ಲದೆ ಹೋದ್ರು ಕೊಡಿ ಅಥವಾ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲದೆ ಹೋದ್ರು ಕೊಡಿ ಅಂತ ಬಂದಾಗ ಹೌ ಅಂತ ಈಗ ಕಂಡೀಷನ್ಸ್ ನ ಹೆಂಗ್ ಇದ್ ಮಾಡ್ತೀರ. ಸೇ ದ ಕೋರ್ಟ್ಸ್ ಆರ್ ಆಕ್ಚುಲಿ ಒನ್ಲಿ ಸಿ ದಟ್ ಹೌ ಟು ಕಾಂಪನ್ಸೇಟ್ ದ ವಿಕ್ಟಿಮ್, ಹೇಗೆ ಅವ್ರಿಗೆ ಪರಿಹಾರ ಕೊಡಬೇಕು, ಪರಿಹಾರದಿಂದ ವಂಚಿತರಾಗಬಾರ್ದು ಅನ್ನೋದಕ್ಕೋಸ್ಕರ ಆ ಲಿಬರಲ್ ಆಟಿಟ್ಯೂಡ್ ವಾಸ್ ಟೇಕನ್ ಬೈ ದ ಕೋರ್ಟ್. ಇವತ್ತು ಕಾನ್ಸೆಪ್ಟ್ ಗಳೇ ಚೇಂಜ್ ಆಗ್ತಾ ಇದೆ ಬಿಕಾಸ್ ಆಫ್ ದ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್. ಎಲ್ಲ ಚೇಂಜ್ ಆಗ್ತಾ ಇದೆ, ಗೊತ್ತಾಯ್ತಾ. ಸೊ ಇವಾಗೆಲ್ಲ ಕೋರ್ಟ್ಸ್ ಡಿಸಿಷನ್ಸ್ ನೋಡ್ತಾ ಇದೀವಿ. ವಿ ಆರ್ ಸೀಯಿಂಗ್ ದಟ್. ಸೇ ಹೇಗೆ ನಾವು ಒಂದೇ ಒಂದು ಪಾಯಿಂಟ್ ಆಕ್ಚುಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಸೇ ಯು ವಿಲ್ ಆಲ್ವೇಸ್ ಅವಾಯ್ಡ್ ಬೈ ದ ಲಾ ಬಟ್ ಯು ಶುಡ್ ಬಿ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್. ಕೋರ್ಸ್ ಸ್ವಲ್ಪ ಮಾನವೀಯತೆ ಇರಬೇಕು ಅನ್ನೋದನ್ನ ಹೇಳ್ತಾರೆ. ಜಡ್ಜ್ಗೆ ಮಾನವೀಯತೆ ಇರಬೇಕು ಅಂದ್ರೆ ಕೋರ್ಟ್ಗೆ ಮಾನವೀಯತೆ ಇರಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಮಾನವೀಯತೆ ಯಾವ್ದ್ರಲ್ಲಿ ಇರ್ಬೇಕು ಅನ್ನೋಕ್ಕೆ ನಿಮ್ಗೆ ಈ ಡಿಸಿಷನ್ಸ್ ಗಳ ನೋಡಿದಾಗ ಕೆಲವು ಯು ವಿಲ್ ಪಾಯಿಂಟ್ ಔಟ್ ದಟ್ ಆಕ್ಚುಲಿ. ಅದರಿಂದ ಇಟ್ಸ್ ಎ ಪಾಸಿಟಿವ್ ಸೈನ್ ದಟ್ ದ ಕೋರ್ಟ್ಸ್ ಆರ್ ಪ್ರೋಆಕ್ಟಿವ್. ನೀವು ಜುಡಿಷಿಯಲ್ ಆಕ್ಟಿವಿಸಮ್ ಅಂತ ಹೇಳ್ತಿರಲ್ಲ, ದ ಪ್ರೋಆಕ್ಟಿವ್ ಅಂಡ್ ಇನ್ ಅವಾರ್ಡಿಂಗ್ ಕಾಂಪನ್ಸೇಷನ್, ವಿಕ್ಟಿಮ್ಸ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡುವಾಗೆಲ್ಲ, ಗೊತ್ತಾಯ್ತು. ಅದನ್ನೇ ತಗೊಂಡು ನಾವು ಆ ಕಾನ್ಸೆಪ್ಟ್ನೇ ತಗೊಂಡೋಗಿ ನಾನು CRPC ಹೇಳಿದ್ನಲ್ಲ, in criminal cases also they will adopt this liberal malice in law, malice in fact. Adana odidira. The legal sense, it means willful act done without just cause or excuse, and it is known as malice in law. Of course, I mean, like, ignorance of law is no excuse, ignorance of fact is excusable. Adanella ಹೇಳ್ತಾ ಇರ್ತೀವಲ್ವಾ. ಹಂಗಾಗಿ it's a narrow and popular sense. It means an evil motive, and the same is known as malice in fact. Of course, ಹೊಟ್ಟೆ ಕಿಚ್ಚಿರುತ್ತೆ ಅಥವಾ ಇನ್ನೇನೋ ಬೇರೆ ಟೆಂಡೆನ್ಸಿ ಇರುತ್ತೆ. ಸೊ ಡೆಫಿನೆಟ್ಲಿ ಸೇ liability arises actually. Liability alla, some exemptions can be given when there is malicious fact. Andre maliciousness, no exemption actually. Adana mistake of fact. I don't want to mistake of fact. Malice in fact antandre evil motive, malicious prosecution, defamation, ಇದನ್ನೆಲ್ಲ ನೋಡ್ತಿರ್ತೀವಿ. And liability arises. Ignorance of law ಅಷ್ಟೇ, malice in law ಅದನ್ನ ಹೇಳ್ತಾರೆ, without just cause ಅಂತ ಹೇಳ್ತಾರೆ. I cannot plead the court that I am ignorant of things. ನಂಗೆ ಅದು ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಸಾಧ್ಯವೇ ಇಲ್ಲ. ಹಾಗಾಗಿ ಇದನ್ನೆಲ್ಲ ಹೇಳ್ತಾ ಹೋಗ್ತಾರೆ. ನಾನು ಅದನ್ನ ಟಚ್ ಮಾಡಕ್ ಹೋಗಲ್ಲ. ಸ್ಟ್ರೈಟ್ ಅವೇ ಐ ಟೇಕ್ ಅಪ್ ಜಸ್ಟ್ ದ ಫಸ್ಟ್ ಚಾಪ್ಟರ್. ಅದನ್ನ ಸ್ವಲ್ಪ ಕಾನ್ಸಿಡರ್, ಒಂದೇ ಒಂದು ಚಾಪ್ಟರ್. ಸೊ ಫ್ರಮ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪಾಯಿಂಟ್ ಆಫ್ ವೆರಿ ಈಸಿ. ಡಿಸ್ಟಿಂಕ್ಷನ್ ಬಿಟ್ವೀನ್, ಆಮೇಲೆ ಡೆಫಿನೇಷನ್ ಕಲ್ತಿರ್ಬೇಕು, ವಾಟ್ ಈಸ್ ಎಸೆನ್ಷಿಯಲ್ಸ್ ಆಫ್ ಟಾರ್ಟ್ಸ್ ಅಂಡ್ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಬಿಟ್ವೀನ್ ಟಾರ್ಟ್ ಅಂಡ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂಡ್ ಕ್ರೈಮ್. ಇದ್ರಲ್ಲಿ ಇದ್ದೇ ಇರ್ತದೆ. ಹಂಗಾಗಿ ಅದನ್ನ ಮಾಡಿ. ಸೊ ಭುವನೇಶ್ವರಿ ಏನ್ ಮಾಡ್ಬೋದು?
ಸರ್ ನಾಳೆಗೆ ತಗೊಳಲ್ವಾ ಸರ್?
7:30 ಆಯ್ತಾ?
ಸರ್ ಆಲ್ರೆಡಿ 7:40 ಆಯ್ತು.
7:40 ಆಯ್ತಾ? ಓಕೆ. ನಾನು ಇವತ್ತು ಯಾಕೆ ಸ್ಲೋ ಮಾಡಿದೆ ಅಂದ್ರೆ ಈ ಚಾಪ್ಟರ್ ಬಹಳ ಫಂಡಮೆಂಟಲ್. ಈಗ ನೆಕ್ಸ್ಟ್ ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ಬೋದು.
ಓಕೆ ಸರ್,
ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ಬೋದು. ಇದರಲ್ಲಿ ಏನಾದ್ರು ಅವ್ರಿಗೆ ಯಾರಿಗಾರು ಕ್ವಶನ್ಸ್ ಇದ್ರೆ
ಕ್ವಶನ್ಸ್ ಇದೆ ಸರ್. ಪ್ರದ್ಯುಮ್ನ ರವಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ, ವಾಟ್ ಈಸ್ ದ ಲೀಗಲ್ ರಾಷನಲಿ ಬಿಹೈಂಡ್ ಇಂಪೋಸಿಂಗ್ ಟಾರ್ಚಿಯಸ್ ಲಯಬಿಲಿಟಿ ಇನ್ ದ ಆಕ್ಟ್ ಆಫ್ ಒಮಿಷನ್ ಕಾಂಟ್ರರಿ ಟು ದ ಆಕ್ಟ್ ಆಫ್ ಕಮಿಷನ್?
ಅದೇ wrongful act and wrongful omission. ಒಂದು ಕಮಿಷನ್, ಇನ್ನೊಂದು omission actually. ಅದು in the legal system, these two concepts are very important and prevents ನೋಡಿ. ಈಗ ಯಾಕಂದ್ರೆ omission is also wrong and positively committing that. Both positive and negative, both are recognized. Okay, by giving example you can differentiate what is wrongful act and wrongful omission. ನಾವ್ ಹೇಳಿದ್ದೇನು, when the court says, ಅದಕ್ಕೆ ನೀವು jurisprudence ಓದುವಾಗಲೂ to do and ought to do ಅಂತ ಹೇಳ್ತೀವಿ. There's a mandate, I'm saying that. So when the law says that law should be strict, I'm saying that rigid ಅಂತ ಹೇಳಲ್ಲ, law should be strict and say don't do this, do this ಅಂತ ಹೇಳಿದಾಗ, say then only you can send a message to the society that say preventive measures are more important than after deciding that. ಹಾಗಾಗಿ ಅವ್ರು ಕಾನೂನು ಹೇಳುತ್ತೆ ಮೊದಲೇ say positive wrongful act ಗೊತ್ತಾಯ್ತಲ್ಲ, so you are responsible. Say wrongful omission, you are responsible, of course, ಗೊತ್ತಾಯ್ತಲ್ಲ. ಹಾಗಾಗಿ this is very very important. Okay, ಏನಾದ್ರು any clarification required?
Okay, sir. There is no question in the chat box as such. So students, anyone having doubt regarding the first chapter, you can raise the questions to sir directly. So unmute your mic.
ಏನೋ 6 ಇದೆ ಚಾರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, 6.
Yes sir.
ಇನ್ನೇನಾದ್ರು ಕ್ವೆಶ್ಚನ್ಸ್ ಇದ್ರೆ ಕೇಳಿ.
So ಯಾರಾದ್ರೂ ಕ್ವೆಶ್ಚನ್ಸ್ ಕೇಳೋರಿದ್ರೆ they can directly ask to the sir only. ನೀವೇ unmute ಮಾಡ್ಕೊಳ್ಳಿ mic ನ, so you can ask. ಯಾರ್ದು ಕ್ವೆಶ್ಚನ್ಸ್ ಇಲ್ವಾ?
ಏನಿಲ್ಲ, ಫಸ್ಟ್ ಚಾಪ್ಟರ್ ಆಕ್ಚುಲಿ ರೆಕಗ್ನೈಸ್ ದ ಲೀಗಲ್ ರೈಟ್ ಅಲ್ವಾ, ಡ್ಯೂಟಿ ಆಫ್ ಡಿಫೆಂಡೆಂಟ್. ನೋಡಿದಾಗ ಸಾಲ್ಮನ್ ಬೇರೆ, ವಿನ್ಫೀಲ್ಡ್ ನೋಡಿದಾಗ, ಸೊ ಫಸ್ಟ್ ಚಾಪ್ಟರ್ ಏನಂತಂದ್ರೆ ರೆಕಗ್ನಿಷನ್ ಆಫ್ ಲೀಗಲ್ ರೈಟ್.
ಪ್ರಕಾಶ್ ಎಸ್ ಅನ್ನೋರು ಹೇಳ್ತಾ ಇದಾರೆ, ಕನ್ನಡದಲ್ಲೂ ಸ್ವಲ್ಪ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್ ಅಂತ. ಸರ್ ಇಸ್ ಡೂಯಿಂಗ್ ದಟ್. ಪ್ರಕಾಶ್ ಅವರೇ ಆಲ್ರೆಡಿ
ಅದೇ ಡೌಟ್, ಯಾಕಂತಂದ್ರೆ ಎಷ್ಟು ಜನ ಕನ್ನಡ ಎಷ್ಟು ಜನ ಇಂಗ್ಲಿಷ್ ಇರ್ತಾರೆ.
ಎಸ್ ಸರ್
ಬಟ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ.
ಹಾ ಸರ್
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ. ಡೆಫಿನೆಟ್ಲಿ ನಾಳೆಯಿಂದ ಕೆಲಸ ಮಾಡ್ತೀನಿ.
ಸರಿ ಸರ್, ಆದ್ರೂ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಸ್ತಿನೇ ಹೇಳಿ ಸರ್, ಯಾಕಂದ್ರೆ ತಮಿಳ್ನಾಡು ಹುಡುಗರೆಲ್ಲ ಜಾಸ್ತಿ
ತುಂಬಾ ಇರ್ತಾರೆ. ಅದು ದಟ್ ಇಸ್ ದ ಅಪ್ರಹೆನ್ಷನ್.
ಎಸ್ ಸರ್
ಅದಕ್ಕೆ ಸ್ಲೋ ಆಗಿ ಹೇಳ್ತಾ ಇದೀನಿ, ಫಾಸ್ಟ್ ಆಗಿ.
ಓಕೆ ಸರ್,
ತುಂಬಾ ಸ್ಲೋ ಆಗಿ ಹೇಳ್ತಾ ಇದೀನಿ.
ತುಂಬಾ ಸ್ಲೋ ಆಗಿ ಚೆನ್ನಾಗಿ ಬರ್ತಾ ಇದೆ ಸರ್.
ಅದಕ್ಕೇನೆ ಕ್ಲಾರಿಟಿ ಇರ್ಬೇಕಲ್ವಾ, ಫಾಸ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ ಅದಾಗುತ್ತೆ, ಹಂಗಾಗಿ. ಎಸ್
ಸರ್. So this is an end of today's session. So I thank everyone who had joined. I thank my all principal sir who had joined for a while, and thanked sir also. And I thank all my colleagues who have joined there and stood with me and supported me in conducting this webinar. And even I want to thank Dr. Deepu, who has joined for a while, and she actually there in the session. So I thank even her, sir, Principal Vidyavardhaka Law College, Mysore. And there are some comments who is telling you thank you, sir.
Vasudev sir, Bhubaneswar madam, with your permission.
Yes,
Vasudev sir, it was a very good session, insightful session, sir. Thank you very much.
Yes,
thank you.
Yes, madam. Every time, madam, every time, whenever we listen to sir, it's an insightful session only.
Yeah, it's like a child's play. Reading, listening to law of thoughts from Vasudev sir is like, he sounds like law of thoughts is a child's play. But only when students start writing the answer, they'll know how difficult it is.
Yes,
yeah, 100%.
ತುಂಬಾ ಕಷ್ಟ ಮೇಡಮ್.
Thank you so much for your
ಯಾಕಂದ್ರೆ ಫುಲ್ ಆಫ್ ಕೇಸ್ ಲಾಸ್. ನೆನ್ನೆ
ಹೌದು
ಜಸ್ಟಿಸ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಬಂದಿದ್ರಲ್ಲ,
ಹಾ
ಲಾ ಆಫ್ ಥಾಟ್ಸ್ ಮಾಡೋರ್ಗೆ ಮೆಮೊರಿ ಚೆನ್ನಾಗಿರುತ್ತೆ ಅಂತ.
ವೆರಿ ಗುಡ್, ಇಟ್ ವಾಸ್ ಎ ಕಾಂಪ್ಲಿಮೆಂಟ್.
ಅದು ಯಾಕಂದ್ರೆ ಕೇಸ್ ಲಾಗಳು ಬೇಗ ಜ್ಞಾಪಕ ಬರಲ್ಲ ಅವ್ರಿಗೆ.
ಎಲ್ಲ ಮತ್ತೆ ಸರ್ ಎಲ್ಲ ವೆಸ್ಟರ್ನ್ ಕೇಸ್ ಲಾಗಳು ಸರ್, ಯಾವ ಹೆಸರುಗಳೇ ಹೇಳಕ್ಕೆ ಕಷ್ಟ. ಇಂಡಿಯನ್ ಕೇಸ್ ಲಾ ಆಗಿದ್ರೆ ಈಸಿ ಆಗ್ಬೇಕು.
ಹೌದೌದು. ಇದೆಲ್ಲ ಪಿಪಿಟಿ ಕೊಡ್ತಾರೆ ಜೊತೆಗೆ.
ಪಿಪಿಟಿ ಐ ವಿಲ್ ಶೇರ್ ವಿತ್ ಯು, ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್. ನೀಟಾಗಿ ಎಷ್ಟು ಚೆನ್ನಾಗಿ ಪಿಪಿಟಿ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ನಾನು ಕೊನೆಗೆ ಶೇರ್ ಮಾಡ್ತೀನಿ. So tomorrow again we can meet on the same time, sir.
Okay.
And with the same link.
Okay.
Students, you have to join with the same link.
Okay.
Okay. Thank you one and all.
Okay.
Thank you, ma'am.
Thank you so much, sir. Good night.
Thank you, madam. Thank you.
Good night, sir.
Thank you. Good night.